Somewhat weak.
Yes, yes, Your Honor. My lord, he is in detention. This is the reason I have filed an IA.
Okay. We'll pass the order. The necessary corrections shall be done.
Yeah, I have filed an IA.
You file an IA.
Yes, sir.
I will come.
Deeply would.
May please do. May please do. I wish to mention item number 24 of Chhatri Material Ismail. I on behalf of S.B. Chaudhary. Matter may be possible, matter will be listed after vacation.
May I please adoption. But I beg to mention for item number 7, item number 7. So in this case, my lord, I am supposed to file an interlocutory application, my lord, because my lord. My lord. Obliged.
Have been circulated. Attestants that John today. List of transferring puja vacation on a date to be fixed by the right. Item 3 and 6. Yes.
May please, Lordship, I am on behalf of J.C. Gogoi. Kindly, item number 4 is possible for.
No, let the matter be called. Except for these two matters, we are calling all the matters. We will entertain the.
This matter is not
matter
well,
in
he is admitted to the.
Whatever, we need the prayer when the matter is
Obliged.
called. Yes, item 1.
No, please order.
Guilty admission in detention.
Not detention, my lord. WBC criminal.
Oh, it is in police surveillance.
Yes, yes. WBC like police servant. How? Bureau for a Kennego collect police. ওরা তো এটা পুলিশ না সব বুঝতে কালের ফটো আছে বলে কালের ফটো কত নাই এসে পুলিশে ইনস্ট্রাকশন সাইবারই খুব কম Oh, instruction আমি শুধু instruction up to date instruction আছে ওটা instruction focus করো
Mr. Sharma, this does not answer our query. It does not answer the court query was not answered.
yesterday I received that it was one SP vendor পুলিশ তো নাই এতিয়া থাকতে only question
Mr.
Today-
Sharma, this is without any warrant, without any, what do you call it? Without any sort of order from any superior authority, they have posted policemen in the house.
মানে
They can stay in the road, but they cannot be in the
police
house.
now my lord I have started of police already no police in the surrounding house earlier man he is a cyber crime he is hiding that house police search that house only and he is absconding main
No, that's okay. You can post the person outside the house, but not inside the house.
Today morning, I have talked with my client, my lord. Still the police is inside
Is
the
there?
premises, my lord. And they gave me some photocopy and one of yesterday, my lord. It's visible, my lord, in the boundary inside the house.
Show it to Mr. Sharma first.
तेईस तारीख 23 হয় 24 সকলে 11টা ইয়াৰ পিছত ওলাই গৈছে আজি ৰাতিপুৱা কথা নাই 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 This 5 up to 11:21 police was there but in night my lord I already
No, whatever be, but since today is the last court, we are making it clear that no police picket inside the house.
yes
First on.
lost yes thank you
But Mr. M.A.I. Hussain, learned counsel for the petitioner. Next. item. Pursuant to order dated 22/9/2025, Mr. P. Sharma, learned additional senior government advocate, has produced the written instructions dated 25/9/2025, received from the office of the senior, issued by the senior superintendent of police, Nagaon. Who is that?
I have given, my lord.
Next. brother. In brief, the case of the petitioner is that a police team has been deployed in the house of the petitioner around the clock and thereby the family of the petitioner is under surveillance. Accordingly, the aggrieved petitioner has filed this writ petition under Article 226 of the Constitution of India, alleging continuous harassment to the family members of the petitioner. Next, brother. as per the instructions received by the learned additional senior government advocate, comma, the concerned accused person is involved in a cyber crime and financial fraud, and after cheating gullible people, comma, the said prime accused and his wife has fled from this from their place of work and residence. Full stop. During house search, comma, certain incriminating materials have been recovered by the police, which includes the incriminating materials, the details of which the court is not inclined to disclose at this moment in view of the as the investigation is in the nascent stage. Full stop. It may be pertinent to mention that during house search, comma, the police has also recovered a notice under section 41 within bracket small a CRPC, the 41 capital A, not within bracket, 41 capital A. Yeah. Issued by the Cybercrime Police Station, comma, Kaimur, Kaimur, within bracket, Bhapua, Phapphua, bracket was Bihar, and it is submitted, and it is further stated that the search conducted in the house of the prime accused was videographed. Be that as it may, as there is no reference in the state written instructions to the effect that there is a order by the competent court for putting the house into surveillance. Court is inclined to provide that the senior superintendent of police, Nagaon, within bracket, respondent number 3 shall take immediate steps to withdraw the police personnel from inside the house of the petitioner. However, comma, there shall be no restriction to the police personnel to make a camp outside the compound of the house of the petitioner. So deemed fit and proper. Next. Next para. the court takes notice of the huge numbers of cybercrime being reported, where the various gullible people are swindled of large sum of money. And therefore, it is to enable the law enforcing agency to complete their investigation. The court has permitted the police surveillance to be allowed from outside the campus of the house of the petitioner and the prime accused. Next paragraph. As there are several disclosures made in the written instructions dated 25/9/2025, the court is inclined to return the said instructions. So the learned additional senior government advocate, in the interest of the investigation. Next paragraph, the petitioner shall produce a certified copy of the order before the respondent number 3 to bring the order to the notice of the said authority. Next paragraph. In the meantime, the learned senior government advocate shall also send a downloaded copy of this order to the respondent number 3 to bring the order to the notice of the said authority. Next paragraph. List the matter again on 24/10/2025. That police picket has to be withdrawn. We are returning you this letter. We don't intend to.
I have that copy, Your Lordship.
No, since the disclosures made, we are returning it to you.
Outside
And we
the,
have- Outside the house, they can surveillance
Yeah.
because it's a menace.
that's okay, my lord. If there is any, there is a allegation of crime, my lord, that can be the. My lord, hello, bless. Within how many days I will start this order, my lord?
It is your choice. You want to
Hello.
do it today, you do it today. You want after
Today,
15
if
days,
I
it
got
is
the
your
copy,
choice.
my lord, I will submit
We
tomorrow.
won't take away constitutional right
I'll
from
get this
you.
on my side, my lord, because highly obliged, my lord.
Item 2.
Wait, please, Your Lordship.
It's-
This is the petitioner before Your Lordship is a wide impugn order dated 25/1/2024.
Page.
Ex parte order, Lordship, page 71, annexure 21. And the notice was not served to the petitioner. It was hanged, and you, Lordship, will find the paragraph number 2, Lordship. Lordship, may I read, Lordship?
Mr. Sharma. Yes. In face of the order, it is wrong.
As per order, Lordship, notice was not properly served. Lordship.
It is at right. Send it back. But as Nasir learned counsel for the petitioner, as well as Mr. Swanson for the respondent. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 25/1/2024, passed page 72. Right. So and so, thereby accepting the notice to be duly served on the petitioner as per section 3(5)(g), 3 within bracket 5 within bracket G of the foreigners within bracket travelers order 1964, and the petitioner was declared to be a foreigner of post 25/3/1971 Spain. Next paragraph. In course of hearing, the learned standing counsel for the FT matters has opposed the prayer of the petitioner for interference with the impugned opinion on the ground that the petitioner had left her residence without informing the government official, and therefore the notice was served served in the manner as provided under paragraph 2 of the impugned opinion. Next paragraph. In view of the serious objection by the learned standing counsel for the FT matters, the court is inclined to quote paragraph 2 of the impugned opinion dated 25/1/2024, by which notice was accepted to be duly served. Paragraph 2, page 72. Next paragraph. It is observed that time and again the court has issued various directions in individual cases regarding the manner in which the manner in which notice has to be served, as provided under the foreigners within bracket tribunal bracket close order, 1964, yet, it is noticed that in this order, in the impugned opinion, the learned tribunal has not considered the provisions of section 3 within bracket 5 regarding the manner in which processes are required to be served. Therefore, it's deemed appropriate that the provisions of order 3 within bracket 5 of the foreigners within bracket tribunal bracket closed order 1964 is be quoted below. This book, paragraph 5, A to J. A to J. 5A to J. Page number 160 to 171, 161. Next paragraph. From the provisions of section 3, order 3(5)(g) quoted above, the requirement is that the notice is to be pasted in a conspicuous house, a conspicuous place of the residence of the proceedee. However, the said procedure is absent in paragraph 2 of the opinion dated 25/1/2024. Next one. Resultantly, as the learned member, Foreigners Tribunal, Jorhat, has accepted the service of notice with total disregard to the provisions of section of order 3 within bracket 5 within bracket G of the foreigners within bracket tribunal order, 1964, the court does not find any reason to even call for the records to examine as to whether the opinion rendered by the impugn opinion rendered by the learned tribunal is in accordance with law. Of the statement, the observations made by the learned tribunal in paragraph 2 of the impugn opinion, it's sufficient to hold that the ex parte proceedings against the petitioner is not sustainable on facts and in law. Next. As the court has been passing repetitive orders regarding manner in which notices are required to be served, court is inclined to provide that the Home and Political B Department, on receipt of a copy of this order, shall circulate a copy of this order to all the foreigners tribunals functioning in the state, so that the provisions regarding service of notice, as provided under the foreigners within bracket tribunal bracket order, 1964, is henceforth scrupulously followed. Next paragraph. Resultantly, the impugn opinion dated 25/1/2024 not found sustainable, and the same is hereby set aside. Next, as the petitioner has appeared through through her learned counsel, the petitioner is directed to appear before the learned member, foreigners tribunal, Jorhat, on or before 31 on 31/10/2025, without any further requirement of service of notice or appearance. So, on the date of appearance, the petitioner shall produce a certified copy of the order, as well as a written statement of defense, along with all documents on which he intends to rely upon. Next, upon appearance, the learned tribunal shall provide an opportunity to the petitioner to file her evidence and to produce witnesses. And thereafter, an attempt shall be made to dispose of the proceedings within an outer limit of preferably within a period of 4 months from the date of appearance of the petitioner. Next paragraph, it is provided that in the event the petitioner does not appear within the time allowed, it would be permissible for the learned tribunal to treat the petitioner as absent on call and pass the opinion in accordance with law.
Deeply obliged.
The petitioner, how can dispose of?
Supplementary item 11.
Morning. I have received.
Just tell us what is happening.
I have really already minor that.
Statement was taken. Statement taken.
Yes, all confirmed. The card is now CW, under CW. Child welfare.
Oh,
Last page. Everything that's actually.
Yes.
Right. Good night.
Mr. Shah, once the girl is produced, her statement is taken.
Yes.
She perhaps wants to stay with you. Uh,
No, my lord, please now.
she does not say so, but we understand.
Yes. She refused to
We
go.
can read between the lines.
She refused to go with her parents.
We can read between the lines. So, but then the habeas corpus has to be closed now.
Your Lordship, I have one prayer is there, page number 25, Lordship, of the petition. There is one prayer, Lordship, direct the medical authority to about the illegal pregnancy, considering the age and her health and education and welfare,
Oh,
Lord.
that don't worry about that. He is under the able what you call
CWC.
guardianship of the CWC.
Lordship,
CWC.
So
because she is
those
not,
things they will take care of.
yes, Lord, because she is not able to give her consent, just.
No, that
this-
can't be permitted. It depends on the humanity of the girl, and you can't meet her because in the meantime, as per the report, you have been taken into custody. The boy has been taken into custody,
Yes, Lordship.
so you'll not be able to meet her. For that, you'll have to move the JJB. If you want to have visitation right over the minor girl, those will now be within the jurisdictional court, which is the Juvenile Justice Board.
Before JT.
We can't do anything about it. The girl has been recovered and her statement has been recorded and she has been sent to the
CWC.
what do you call at a Seven Sisters home
Yes, ma'am.
under CWC. Right.
Lordship, another prayer, Lordship, the investigation, further investigation of this case may be expeditious, Lordship, because another named accused is their Lordship, because other accused has conspired
Oh,
to
yes,
all
sir.
this.
Not monitoring the investigation and
That is the duty of police.
that you'll have to move the jurisdictional court.
Yes, Lordship, because Lordship, investigation was not properly done, Lordship, in this case. That's why the situation has been arisen, Lordship, this especially.
My lord.
Yes, Lordship,
Police
until and unless
from Rajasthan, my lord,
investigations,
same file.
uh,
Because
because the other family members also involved in this case,
Right,
Lordship.
okay, you have a right to make your submissions, but please consider. Please take a call and consider because we'll be passing orders. It's not that we'll shy away.
No,
When you make your submissions, we'll deal with it.
right.
But the question is whether you want us to deal with the matter. You take a call and make your submissions. If you make submissions, we'll pass orders.
Mr. Lordship, the victim is also agreed, given consent to go with the termination abortions, Lordship. That is important because the 5-6 months she entered, Lordship, and but she has voluntarily given the her consent to go through this process, Lordship. So that should be also considered, Lordship, because it is her health, education, and welfare, Lordship. It is to be taken into consideration, Lordship. Yeah, paramount, Lordship.
When we understand, when you elope with a minor girl, just
Year 1965 is at page number 58 and 59, Lordship. Where is grandfather's name, Lordship? Pali Sheikh, grandmother Julekha Khatun, and his father Tahir Ali's name is. Has
you
appeared.
have the entire set of the order sheet with you.
Lord,
It was the certified copy of the order sheet you which you have.
Lordship, original copy I have. It is not with my. It is not in the record, but I have annexed here, Lordship, all the orders and
You
also
have
the type
annexed
copies.
it, you have annexed it. That is why we are asking that question. You have the entire set. You said no.
I have, Lordship. We have.
You have it today. No. It's okay. Proceed.
Lordship, whatever order I have annexed, these are all the orders. I have not missed any order, Lordship. So, Lordship, as the possesses required documents and records, so my humble submission is that he shall be granted one last opportunity to file a written statement, Lordship, to prove his nationality as an Indian. And there is an apprehension that he can be detained at any time. Interim protection may be granted, Lordship. And the prime reason for non-appearance, Lordship, due to the non-communication, and he's a construction laborer, means he's a laborer who works at construction sites. So he used to go out of his town for his work, Lordship.
If that be so, you see, we are in also search of learned counsel like that,
Lordship.
because we want to honor such advocates, and then we want to include them in the team of our district legal services authorities also. We also want to know names of such lawyers who will go and search for you. You say that you are a laborer. They will go and search for you, find you out, give you the next date,
No,
inform you about how to come to court. We are also in search of such learned counsel, because many times we get complaint that the advocates do not communicate. We want to make you famous.
Lordship. Lordship, the petitioner.
Can you give us an undertaking by the end of the day today that in your professional career, henceforth you will always go to the home of the client and then inform? Can you give an undertaking?
Lordship, I was not the engaged counsel, Lordship.
I understand. You should set an example.
No, no.
Can you give an undertaking that henceforth to every client you will go and deliver home service, go to their home, inform about the next date?
Lordship, it is also duty of the petitioner to.
No, you are
Okay.
making an allegation against the council that he did not communicate.
No.
We are trying to find out if you can do the same.
No, Lordship, not allegation.
You
This
can't
is-
do it.
This is the
So
reason.
Can this allegation against the advocate sustainable?
No, Lordship, not at all.
No.
Lordship, in view of his records and required sufficient documents, Lordship, my humble prayer is that one last opportunity, Lordship.
But
And
this
on
court
the,
gave you an opportunity. Very specifically stated in page 41 that you will file your written statement.
but if your Lordship allows one last opportunity on the very next day, Lordship, will be filing the written statement.
No, I am a heartless fellow.
Lordship.
I am not saying about my sister. She is very moved. Smallest thing happens, she gets very emotional. But I am a heartless person.
No.
You should disregard to the order of the court.
Lordship, I have.
No. And what is your explanation from 2021 to
Lordship,
2025?
25 from the impugn order dated to till date, Lordship, my explanation, honest explanation is that the petitioner was under the impression that his case is over. And presently, Lordship, due to this eviction taking place all over the state, the police came searching for him in his address. And thereafter, the petitioner came to know that his case is not yet over, and he was already declared as a foreigner, Lordship.
From there is that. The having put the done counsel for the petition to notice, he has made his submissions in the matter, stating that the petitioner had entered appearance, that pursuant to the order of this court, the petitioner had entered appearance on 8/12/2019 and paid for bail, which was allowed. And thereafter, the matter was fixed on 16/12/2019. 13/1 to 2020 and 24 to 2020. But written statement could not be filed, and thereafter, due to COVID-19 pandemic, the petitioner could not take steps for filing of the written statement. So it is also submitted that in the meantime, the petitioner's advocate did not inform the petitioner about the dates fixed in the proceedings, and also did not enter appearance on a few dates. And in the meanwhile, the matter was heard and decided ex parte on 25/1/2021. It is submitted that the petitioner has sufficient documents to show that he is a citizen of India. Accordingly, it is submitted that the non-appearance or non-filing of the written statement within the extended time by the learned tribunal was inadvertent, as the then engaged counsel for the petitioner did not inform the petitioner about the dates as well as the date fixed for ex parte hearing. In respect of the delay in delay in latches in issuing the ex parte opinion dated 25/1/2021 by filing this writ petition on 19/9/2025. The learned counsel for the petitioner has submitted that the petitioner was under an impression that the matter was over, and he was not communicated about the ex parte opinion rendered against the petitioner, declaring him to be a foreigner. And it is only when the police personnel from the jurisdictional police station came to the house of the petitioner in the month of July 2025, searching for him. He became aware of the ex parte opinion rendered against him. It is further submitted that the petitioner is an illiterate person and works as a laborer in the construction site. Accordingly, it is submitted that the delay in filing of this writ petition be condoned and one opportunity be granted to the petitioner to file his written statement. Next, here made in this application is opposed by the learned standing for the FT matters. Next, the from the order dated 18/11/2019, passed by this court in WPC 5890 of 2019, we should take note of the fact that an ex parte opinion had already been passed against the petitioner in FT case number 22 of 2017, declaring him to be a foreigner. This court, having accepted the plea of the petitioner, had set aside the ex parte opinion dated 8/12/2017. To stop at that time, the petitioner was already was taken into custody. And accordingly, as per order dated 18/11/2019, the court had directed that the petitioner who was taken into custody in May 2019 and lodged at the Jorhat Central Jail be produced before the Foreigners Tribunal, Tipu, on 6/12/2019. And the court has had further directed that the tribunal shall fix the date, the next date within a reasonable time, enabling the petitioner to file written statement and documents. And it was made very clear in this said order dated 18/11/2019 that the proceedings before the tribunal shall be concluded within a period of 60 days from 6/12/2019. Full stop. Under such circumstances, on examining the materials annexed to this writ petition, documents annexed to the writ petition, we find that the proceedings before the learned tribunal were taken up on 8/12/2019, 16/12/2019, 13/1/2020, 24/2/2020, 5/6/2020, 8/7/2020, 31/8/2020, Twenty-eight 9/2020, 12/10/2020, 2/11/2020, 3/11/2020, and 13/1/2020, 21. Next. According to this, it's seen that that though the petitioner was aware that the tribunal was required to dispose of the proceedings within 60 days, but for one reason or the other, the petitioner did not file his written statement of defense and did not need any evidence to discharge his burden of proof under Section 9 of the Foreigners Act, 1946. Next one. We are unable to accept the allegation against the petitioner that the advocate of the petitioner that he had not informed the petitioner about the next date fixed by the learned tribunal for written statement, comma, and the full stop. Petitioner has not been able to demonstrate any act or rules governing the advocates that the advocate had owed any duty to inform the petitioner about the next date fixed in the proceedings in which the counsel is engaged. Full stop. As this court had already provided by order dated 18/11/2019 for the petitioner to be produced from jail on 6/12/2019 and providing for the written statement to be filed on the next date. It was incumbent on the part of the petitioner to understand the set order of this court and to scrupulously follow the same. Next. The ex parte opinion was rendered on 25/1/2021. And the petitioner has made a challenge to the said ex parte opinion by filing this writ petition on 19/9/2025. Thus, it also demonstrates that the petitioner did not make any attempt to meet his advocate and to know about the fate of this case. Next. In the considered opinion of the court, the right to defend in the proceedings where the citizenship of the petitioner is involved cannot be extended so as to render the exercise of partial exercise by giving limitless time the petitioner to discharge his burden of proof under section 9 of the Foreigners Act of 1946. The provisions of Order 3 within bracket 14 of the Foreigners within bracket Tribunal bracket Order 1964 mandates that the Foreigners Tribunal shall dispose of the case within a period of 60 days of the receipt of the reference from the competent authority. So, under such circumstances, the opinion rendered for the second time, ex parte opinion rendered for the second time, only demonstrates the continuous default on part of the petitioner to file his written statement of defense and to contest the proceedings by discharging his burden to prove that he's not a foreigner. Next paragraph. The learned counsel for the petitioner is referred to the documents next to the petition, which it's so that he's a bona fide citizen of the country. This court, in exercise of certiorari jurisdiction, would not venture to examine a document which was hitherto not produced and proved before the Foreigners Tribunal. Next, on the circumstances as indicated above, court is of the considered opinion that the learned Foreigners Tribunal gave more than sufficient opportunity to the petitioner to file his written statement of defense and to examine with the petitioner did not await for the circumstances as the delay and latches to seal the opinion dated 25/1/2021 by filing this petition on 19/9/2025 have not been satisfactorily obtained, and as the petitioner has not been able to demonstrate any good reason for not filing his written statement in compliance with the directions contained in the order dated 18/11/2019 at the division bench of this court in WBC 5890/2019. court is of the considered opinion that the petitioner does not deserve any further opportunity, as it would render the determination by the foreigners tribunal of partial exercise according to the witness and dismissed at the motion stage without issuance of notice on the conference. The registry shall transmit a copy of the order to the concerned the foreigners tribunal bureau, putting the order to the notice of the said authority and to make it a part of record.
Item 11.
May please your lordship. But still, I may be granted liberty.
Or
Lordship, as it is dismissed, lordship, and
pardon me,
lordship. As
don't be afraid. Don't be afraid. We dismiss the matter. We are not dismissing you.
lordship,
You please feel free. I don't want you to be uncomfortable.
lordship, my humble submission still now, lordship, that one last opportunity shall be granted,
No,
lordship.
that we refused. We have dismissed it.
Lordship.
That we have dismissed. That we have rejected. You see, please don't be afraid. We don't want a lawyer to be afraid of speaking before the court. Although we have dismissed the matter, but we are not dismissing you. Correct. You will always remain the officer of the court. Please be comfortable.
Lordship, in
Correct. We don't want to discourage you as a lawyer making submissions. Correct.
lordship,
It's a matter we have dismissed. We are not dismissing you. Please don't misunderstand us. Correct.
lordship, therefore, my lordship, in that regard, my prayer for one last time will be, lordship, that
No, that we have rejected because we did not find any merit in the matter. Therefore, we have rejected it.
lordship, one reason for my making my submission is that he possesses required documents and records, lordship.
So we understand that, but we have taken note of that. You see, we have taken note of that, and we have not desired to go into the document because it is the High Court. We are not examining the documents which ought to have been done by the tribunal.
Lordship.
Correct.
So, lordship, as lordship have already dismissed the matter, but lordship, if moreover, lordship, he is the only earning member and he please do some studying in the.
We can't help it. We have given that opportunity. High Court gave you an opportunity, made you a date to be disposed of within 60 days.
Lordship,
After that, we are unable to accept it. We have a limitation. Correct.
lordship may put whatever condition lordship wants, lordship.
We understand, but we have rejected it. Correct. And we don't want you to be afraid. You are with full liberty to address the court in the manner you want. Correct. We don't want to discourage you. We have also, you see, from the stage you are growing, it is from that stage only we have come here. Had the court did not give us an opportunity of expressing, perhaps I would not have been here. Correct. So we don't want you to discourage you as a lawyer. Correct.
Exactly.
It's only a matter which we did not find any merit and we are dismissing it. But we have considered your submissions and we have recorded it. Okay?
Lordship.
Item 11.
Respondents. Next para. In brief, comma, the case of the petitioner is that his daughter, projected to be a minor, had eloped with respondent number 6 pursuant to investigation that was carried out was after lodging of the FIR and registration of volume of PS case number 111 of 2025, the victim was recovered and that his minor daughter was recovered. And the petitioner had gone to the place where the girl was recovered in the state of Bihar and brought her back to Guwahati. Full stop. The IO had produced the daughter of the petitioner before the it just said from the Bihar, it says Samastipur. You had given us a letter earlier. No, that's a they looked at left to Samastipur, and from Samastipur, the girl of the petitioner and the respondent number 6 had gone to Ahmedabad. And with the assistance of the local police, the daughter of the petitioner was brought from Ahmedabad to Samastipur in Bihar, and from there, the petitioner brought his daughter to Guwahati on 22/7/2025. So, on 23, the investigation report produced by the learned additional senior government advocate on 16/9/2025 discloses that on 23/7/2025, the daughter of the petitioner, accompanied by her mother, was examined by the IO, and her statement was recorded, wherein she had admitted that she has been in relationship with the respondent number 6 since last 1 year, and admitted having physical relationship. Full stop. However, after the daughter of the petitioner was released to the custody of her mother on 23/7/2025, And thereafter, on 25/7/2025, the daughter of the petitioner was produced before the CWC, Kamru Metro, where she was accompanied by both parents. And after counseling, the daughter of the petitioner was allowed to go with her mother. Full stop. However, once again, the daughter of the petitioner had eloped with respondent number 6 for the second time, and a verbal complaint to that effect was made before the Barolme police station on 29/7/2025. Police stop. As per the investigation report, the suspect and the daughter of the petitioner were changing locations, and therefore they could not be apprehended. And accordingly, orders were passed over on 16/9/2025. Directing the officer in charge of the Barolme police station to do the needful. So next, the matter was then listed on 24/9/2025, and the learned senior government advocate had submitted that in the meanwhile, the accused as well as the daughter of the petitioner were apprehended from Rajasthan, and they have been brought back and were likely to be produced before the concerned court. Accordingly, the matter was ordered to be listed on today, 26/9/2025, and the learned additional senior government advocate has produced the updated investigation report. Which discloses, inter alia, that the that on 25/9/2025, when the daughter of the petitioner was produced before the CWC, Kamrup Metro, escorted by a women police personnel and her mother, the victim. The daughter of the petitioner had made a categorical statement that during her earlier production before the CWC, she had agreed to go for medical termination of pregnancy only because of the fear of physical punishment from her parents, due to which she had again ran away to Bihar from her home. So she has stated that in Bihar, her marriage was accepted socially, and she has made a categorical statement that in no condition she is ready to terminate her pregnancy, and she has also expressed that she is ready to stay in the child care institute within bracket CCI for short till delivery, and she is not willing to go home. Pushpa. Along with the next para, along with the investigation report, comma, the learned additional senior government advocate has also produced a copy of order dated 24/9/2025, passed by the learned special judge, comma, POXO, comma, Kamrup Metro, comma, Guwahati, in connection with Borolimuk PS case number 111 of 25 under section 96/3 within bracket 5 BNS, read with section 6 of the POXO Act, where the learned special judge has recorded the clear made by the investigating officer about the unwillingness of the girl to go with her parents as she was complaining of torture by her father, i.e. the petitioner. Next para, be that as it may, in view of the lack of consent of the daughter of the petitioner for undergoing medical termination of pregnancy, comma, court is only of the considered opinion that a request be made to the CWC to ensure that due medical care is provided to the and counseling be provided to the minor daughter of the petitioner during a stay in the CCI. Next para. The learned counsel for the petitioner has submitted that in this writ petition, in this habeas corpus petition, the petitioner has made a prayer for protection of the victim before the court and to secure her release from the legal detention and to direct the medical authority to abort the pregnancy and for the prayer to recommend disciplinary action against the officer in charge and the IO of the case and to transfer the case from Borolme Police Station to the Criminal Investigation Department. Next one. Heard the learned additional senior government advocate in respect of the prayers made. Having considered the nature of investigation done so far, including recovery of the daughter of the victim of the petitioner twice from out of state. We find no reason to exercise extraordinary jurisdiction of this court under Article 226 of the Constitution of India. Either recommend any disciplinary action against the officer in charge and the IO of the case, officer in charge volume position of the IO of the case, or transfer the proceeding, transfer the investigation to any other authority. Next paragraph. As the CWC has categorically recorded in its order dated 25/9/2025 that under no circumstances the girl of the petitioner is ready to terminate her pregnancy, under the circumstances, court having noticed from the report of the from the order dated 25/9/2025 by the CWC that the girl is pregnant by more than 6 months, or the court is disinclined to pass any orders for termination of pregnancy of the daughter of the petitioner. Next paragraph. As the purpose of this habeas corpus petition is served by production of the daughter of the petitioner before the concerned court, court does not find any reason to prolong this matter any further, as it would be within the domain of the jurisdictional magistrate or the jurisdictional court to deal with the matter. It is a court of the JJB, Juvenile Justice Board. To pass appropriate orders in respect to the daughter of the petitioner, in the event is found to be a minor. Accordingly, the matter stands closed. With a request to the CWC, Kamru Metro Party to give adequate care and protection to the daughter of the victim in terms of her wishes and desire. Next paragraph, in the event the petitioner wants to have visitation right to meet her daughter, it would be open to the petitioner to move the jurisdictional court public JJB, Juvenile Justice Board, would be having the competence to pass appropriate orders. According to this habeas corpus petition stands closed.
Item 12.
My lord,
Yesterday you gave us a lot of problem. You told us in the matter which you moved yesterday that it was similar order. We told you that we'd examine the case and pass orders. You remember that yesterday matter?
yes, my lord, item 13.
Item
13.
13. When we check the records, we find it different. In the earlier case, the process service report was there. In your case, you have not produced it. How it can be similar? We had to pass orders fixing a date for appearance. You see, we trusted you. We told you that we would dispose of the
No,
matter.
no, my lord, he is not in that.
And that trust you have betrayed. You should have told us that the service report is not there. In the earlier order, we had categorically stated that
Yes,
annexure K is the service report.
Yes,
You did not tell us the circumstances that it was not there.
sorry.
You betrayed our trust. We
My lord,
trusted you.
My lord, the matter is.
You made a statement and we took it and we said we'll pass orders. We trusted you.
My lord, in the meantime,
And
my lord,
yesterday, division bench orders, full bench orders, then all these files coming home.
Yeah.
And in the meanwhile, we scrutinize your record and we find it different. Do you imagine how much trouble you gave us?
sorry, madam.
Then if we pass a different order, I had to contact my sister, tell her what has happened. And in the process, so much of wastage of time.
Not in the meantime, I will produce
You
my
have,
lord. Yes.
you have
Not,
you have
piece of note.
betrayed our trust. At your statement, we had allowed the repetition. We took it for granted that what you are saying is the truth. But no, you can't be believed any longer.
I'm so sorry.
Yes, in this matter, what has happened?
Yes,
You
Lordship,
got the instructions?
yeah, telephonic instruction I have with Lordship. He just Kukrazar
Sorry,
holding Paracola. 7 PBN.
heard Mr. S. A. Ahmed, learned counsel for the petitioner and Swenson for the respondent. Next para. Pursuant to order dated 24/9/2025, the learned standing counsel for the FT and border matters has submitted that he has received verbal communication from the concerned police authorities that after the petitioner, after the wife of the petitioner, namely, Sukurjan Begum, alias Musammat Sukurjan, was taken into custody on 25/5/2025, she has been shifted to the holding area under 7th AP Battalion, Saraikala, Kokrajhar. Next, accordingly, the court is inclined to grant visitation right to the petitioner, namely Lal Mia, husband of the detained foreign national, namely Sukurjan Begum, alias Musammat Sukurjan, to visit the holding area at the 7th
Holding
AP
center.
Battalion, along with one family member, and on production of a certified copy of the order, the in charge of the said holding area under 7th AP Battalion shall permit the petitioner and one family member to meet the detained foreign national and to take a signature in the Wakalatnama. Next para. List again of 17/10/2025.
Item 14.
Obliging.
Please, Your Lordship. My Lord, before I make my submission, yesterday, as Your Lordship was pleased to give the permission to move the case, there was a objection in respect of Annexure 24, and then I had to give an undertaking. That undertaking is, I think, my Lord, in the main petition, either second page or third page. It is it is on top. The document is Annexure 24 in the writ petition, page 117 to 121. No, I've got it. So, my lord, is it possible your lordship may mark it as X and keep it on the record? So, so this, my lord, I have submitted as I have given the undertaking. I think there is undertaking letter, my lord, if your lordship has got it. Yes, my lord. Yes, my lord.
Six 2025 passed by so and so in FT case number so and so, FT case number, reference FT case number so and so. Thereby declaring the petition to be a foreigner of post petition in 1973. Notice returnable in 4 weeks, extra copies within in course of the day. The relevant record be called for from the concerned tribunal. The prayer for bail is opposed by the learned standing counsel for the FT matter. Considering the projection made in the writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Superintendent of Police Border. Morigaon. Next, the learned counsel for the petitioner has submitted that he had given an undertaking to provide clear copy of Annexure 24 to the writ petition, and accordingly he has submitted a type copy of the impugned opinion dated 26/6/2025. Has he? Say it. You'll have to do it in front of the AOJ. We are keeping it here, but you'll have to go to the AOJ and have it inserted. It said type copy is retained on record. So the learned counsel for the petitioner shall propose the AOJ on my FT section to have the same incorporated as
Annexure 24.
type copy of Annexure 24. List of the 4 weeks on receipt of the tribunal's records. Look, you'll have to do that stitching in front of him.
Now, my lord, my case. Can I make my argument of the case, my lord?
Final argument.
No. Just it's a motion. Notice is, my lord, the stay is required, my lord.
Given your notice, we are giving you bail.
Bail, no, my lord, only thing I think the stay is required, my lord, of the opinion.
No, stay would not be there.
No, but
we are giving you bail.
No, your lordship may see the paragraph 8. I think possibly after looking at the paragraph 8, your lordship will give the stay, my lord.
Paragraph
8.
8 of the writ petition.
No, 8 of this impugned order, my lord. Impugned opinion. My lord, in Assamese one word is that Soddo Gusti, my lord. Paragraph 8, my Soddo Gusti and my wife Soddo Gusti is also involved.
No, but
I don't know why. No, I know while deciding a man's citizenship, whether there is a kind of a sadistic pleasure is very,
No,
I'm sorry to say that word.
Reserve those at the end.
My lord, see
Today we
that.
are giving you bail.
No, but did you see the line, my lord?
We'll have to consider when we examine it.
No, I think your lordship missed out one thing. My family members is okay, as well as against his wife and all her blood related relatives. So as to keep the spirit of the judgment passed by this Aktara
For that, you
Khatun.
see, for that it can't be stated because the reference is a power which the authority has got. Tribunal can say that register a reference, but it has to be only by a reference. This does not take away the right of your wife or children. It merely says that you see, it says it is expected that the superintendent of police would initiate press proceeding against all the family members.
It's okay. Because there is a suspect about me. That is the reason my family members.
No, still, you see that that reference is made. It has to be.
No, my lord, against
Decided.
my wife, that is beyond his jurisdiction.
No. That is permitted by this court. If a person has been detected to be a foreigner, then it would be separate reference against the other family member.
My wife and her blood relatives.
Let it come, then we'll.
My lord, somewhere some stoppage has to be there. It's totally beyond jurisdiction, my lord. My wife is not a proceeding. Nothing. Now see the amount of anxiety because of this order, my lord.
You see, unless the reference unless the documents come, how would you know what the reference is about?
The reference about against me is a total perverse findings. That is another thing, but giving the clincher to the aspect that my family members as well as my wife's and her all blood relatives, I think it's traveling beyond jurisdiction, my lord. Wife is nowhere in the scene in that proceeding, my lord. And I'll prove it, my lord, when the matter is taken up for hearing. Each and every critical analysis is a perverse finding. Lordship. Yes, Lordship. No, yes.
Lordship. I think Lordship, uh, there is no bar to make an inquiry against the wife, Lordship. Oh, yes, yes, right. Yes, yes, that cannot be done, Lordship.
My lord, may I do this first part of putting the typed copy after reopening? Today I have to rush, my lord. Immediately after reopening. Deeply obliged, my lord.
Upgraded item 9.
Days delay in preparing appeal. Lordship, the state is the respondent, BTC and the states. Lordship. We agree delay may be condoned 35 days. Okay, I'm checking for the finance department. I've already given the copy.
Night.
There is a delay of 33 days. Late notice go, at least my lord, I should inform my BTC, my lord. I should need to inform the BTC, my lord. There is a case. Notice. 33 days. 3. Here, my one is 33 days. Registry has spent 35 days. Originally, we find 33 days. Registry has spent 35 days. After calculation is 32. Lordship, I will make it. Already finished. Lordship. FPF. Phone number 226. 2, 5 and 6. Black. Problem.
Item 4. Item 5.
May it please your lordship? Lordship, the matter may be taken up immediately after vacation, lordship. Yes, lordship.
Item 7. Item 7.
My lord, in this case, I am supposed to file on IM item because the petition number 1 has expired. My lord. On earlier occasion also, my lord, time was short, but I could not communicate with the parties. My lord. So I have to do it, my lord. One opportunity may kindly be. Yeah. Obliged.
Item 8.
May it please your lordship. Such a matter may be taken after vacation.
Thank you. Item number 4. He is out of station.
It goes after vacation. Okay.
Motion method.
Mr. A.K. Datta, under counsel, has submitted that he has received instructions from Mr. B. Professor under counsel for the petitioner that he is out of station. All the respondents are present and represented. Matter stands adjourned today. List in the motion column after the ensuing.
My lord, kindly fix a date, my lord. Immediate after vacation.
Okay. 15/10/2025.
Obligement.
May it please your lordship. Lordship, there is a prayer in respect of item number 21. We have filed an additional affidavit on behalf of respondent number 2 and 3. It is not in the record now. Lord, it may kindly be called for.
May it please your lordship. Lordship, I beg to mention item number 6. Lordship, the client has instructed us to engage a senior counsel for the conducting the matter.
Your name?
B person.
The prayer made by Ms. B. Parashar under counsel for the petitioner. The matter stands adjourned today. List after the ensuing vacation.
In this matter, I am referring for Mr. STKR. The name of pending counsel, Tezpur University must be inserted in the corpus.
Okay. This is item number 6. You also add the registration shall reflect the name of SC Tezpur University. We're listing the matter next.
Doctor, but copy may be given to us. Doctor, we have not been the
Ask her,
Doctor.
give her a
But,
copy.
May-
Correct?
may-
Hearing to give her a copy.
May I please, Lordship?
Huh.
I beg to mention item number 11. Lordship, kindly adjourn the matter.
11.
Please after vacation. Item 11.
You want an adjournment?
Item 11.
Want an
Adjournment,
adjournment?
after vacation.
It's not considering critical, it's paid for by the passport of the petitioner.
Blessed.
Yeah, please, your lordship. Victims on item number 19, lordship. I pray for adjournment this matter.
19.
Yes, lordship.
What says a representative of the pair made by the counsel for the applicant? You start answering for your patient.
Oh, bless.
Daily list item 1.
May please.
Yes.
Yeah, in this case, my lord, the petitioner is placed under suspension, my lord. Because of arrest, he was arrested on 12/2/25 and he was placed under suspension on 15/2/25, my lord. And till date, my lord, he has not been reinstated, no any DP has been initiated and any review even is in file, my lord.
The
Impugn order, your
Sir?
lordship will find it at page 19, your lordship.
Mr. R. Chaudhary and talk to the petitioner. By filing this writ petition under Article 226 of the Constitution of India, the continued suspension of the petitioner without payment of subsistence allowance has been assailed. Notice returnable on 24/10/2025. This should be over standing counsel for the taxes. Finance and Taxation Department. Finance and Taxation Department. Finance and Taxation Department accept notice on behalf of all the respondents. So requisite extra copies of the represent this out of came in course of the page. The respondent authorities shall provide necessary instructions to the learned standing counsel for the matters that was to be produced from the next date of listing. List on same returnable date. We have 24/10. Na?
Deeply.
Item 2.
Just a moment. Mr. Gogoi. Mr. Gogoi. Let us see. The pendency of the, before the last date, the pendency of the reparation shall not be a bar to release the substance allowance. If not,
That is receiving. He is receiving the.
Lordship, that
There
has
is
been
no
deleted.
request.
My only
Only
request
for
is
that,
regarding suspension.
no review has been conducted.
you have said somewhere here that without any
Lordship,
substance allowance.
after filing that, we've been instructed.
He has been given. I said then you have to.
Silent.
Item 2.
May please, Lordship. This matter pertains to my lord selection and appointment of Constable GD in Central Armed Police Forces, my lord. Petitioner participated in the, my lord, computer-based examination and he got the cutoff mark and thereafter he was called for, my lord, physical standard
Where
test.
is the rejection slip?
Yes, my lord. Rejection slip is 55. Petitioner Penetra was rejected, citing my lord height is my lord 164.4 and required height is 165 for Assam, my lord. But in the advertisement itself, there is a provision for appeal, my lord, but only 1 day is given, my lord, to prefer an appeal, my lord. The coordinate bench of this honorable court passed some orders, my lord, allowing the petitioner to prefer an appeal within 2 weeks, my lord. There are 5, my lord.
What is the prescription of the
Page
the
56,
test
my
and all?
lord. Page 56.
56.
56, 56, my lord. And operative portion.
No, in the advertisement, where is the standard?
Yes, my lord. What is, my lord? In the advertisement, my lord, is 17 operative portion, my lord.
Yes.
Page 32, my lord.
32.
32. 12.5. 12.5 in the, my lord, box, my lord, serial number D, my lord. For male, my lord, 165. And appeal provision is there, my lord. Appeal provision is page 34, my lord. Page 34. Close 12.5.5.
You filed appeal, no, you have not
No,
filed
not
appeal.
file, my lord.
But what was the difficulty in filing?
My lord, kindly see, my lord, only on the same day, the candidate is required to file an appeal, my lord.
No, even if you could not do in the one day, in 2 or 3 days, why you could not have filed it? Because by now, almost 1 month has gone by.
My lord, on, my lord, this was taken on, my lord, 1/9, my lord. This,
1/9, today is 26th.
yes.
1 month has gone by.
In all other cases, my lord, this honorable court allowed,
Give 1 week more time to file an appeal.
my lord.
Yes, Lord.
But Mr. HR Ahmed and asked for the petitioner, as well as Berber and CC appealing for the respondents. Next one. The case of the petitioner is that pursuant to an advertisement by the Staff Selection Commission for appointment of constable within bracket GD in the in the Central Armed Force Police Forces FRCS, comma SSF and rifleman within bracket GD in Assam Rifles and Sepoy SCPOY Sepoy in Narcotics Control Bureau examination, comma 2025. The petitioner had submitted his candidature so, however, by a rejection slip dated 1/9/2025, the candidature of the petitioner was rejected for recruitment to the post of constable within bracket GD in CAPF capital S small, as he was not found qualified in the PST. So, next for the conditions of the advertisement and the rejection slip giving only this, the requiring the appeal to be filed on the same day. The aggrieved petitioner is approach this court. Next, the learned counsel for the petitioner submitted that under similar circumstances, by an order dated 15/9/2025, passed in WBC 5411 of 2025, this court has granted 2 weeks time to prefer an appeal before the competent authority against the rejection of candidature. So, as well as considering the said order dated 15/9/2025, passed in WBC 5411/2025, the court is inclined to grant 7 days time to the petitioner from the date of the order to prefer an appeal before the competent authority, along with enclosing thereto the a certified copy of this order. On receipt of the appeal filed by the petitioner, the competent authority shall decide the appeal, shall take the appeal on board and decide the same by recent order within an outer period of 30 days from the date of submission of the appeal. Next paragraph. Accordingly, the matter stands disposed of in the motion stage without issuance of notice on the respondents.
Published, Miller.
Item 3.
May it please your lordship. Lordship, this is also similar matter, lordship. Here, there are 7 petitioners, lordship. The rejection slips are from page 49 to 53, lordship.
49 to 53.
Yes, lordship. Petitioner number 1 was rejected for 163.5.
So we same. Petitioner number 1 rejected on rejection slip is dated 2/9/2025. Number 2 is 29/8/2025. Number 3 is 26/8/2025. Number 4 is 27/8/2025. Next is 27/8/2025. Next is 21/8/2025. Next is 22/8/2025. Same order. The name of the counsel is Mr.
D. Deca, lordship.
D. Deca, counsel for the petitioners. 1 week's time to file.
Lordship. I'm highly obliged, lordship. Obliged.
Item 5.
May it please your lordship.
Yes, Mr. Rajat.
My lord, your lordship may turn to page 20. In the year 1999, I was appointed as a 99, I was appointed, my lord. Thereafter, I was as a child development project officer.
You are removed from service.
My lord,
You are removed from service.
no, my lord. I have been transferred. Your lordship will find in page 22 on 28th October 2024. Page 22.
Yes.
It is 28th October. I was from Dotoma to Kokrajhar. I was transferred from Dotoma to Kokrajhar on 20th October 2024. First one.
What's your name? Gitanjali.
Gitanjali Islari. Dated 24th October 2024.
Yes.
Thereafter, my lord, again I was transferred within 10 months on page 30. Page 30 dated 9th August 2025. My name is on serial number 14. 14, Vice 19.
Yes.
From Kokrajhar to Golokganj and from the 19 to in my place. She has not taken over. I filed a representation at page 33 on 29th August 2025, received by them on 7/9/2025.
But this page 30 appears to be a regular transfer.
Regular transfer, my lord.
And then this.
Regular transfer means, my lord, within 10 months. Within 10 months. There is no interest. Then page 33 and 7/9/25, they received it. My lord, and this representation thereafter, when nothing was done, I approached this court. This court directed at page 38. Last paragraph, my lord, I will read it slowly, my lord. This representation shall be disposed of expeditiously as possible, preferably within the outer limit of 10 days from today, till disposal of the representation by a speaking order. Till the disposal of the representation by a speaking order, the impugn order is, in so far the petitioner is concerned, whose name appeared as serial number 14 shall not be given effect to. The speaking order is at page 39, my lord. With reference to subject cited above, I am directed to inform you that your prayer for modification has been regretted. Why? I don't know, my lord. They feel sad. Meaning of regretted is feel sad and fail to do so. This is the speaking order they have passed, my lord. No reason, nothing shown, my lord. Why they have regretted in modification of my transfer order. One line. This is the speaking order they have passed, my lord. And the word is has been regretted. Not every order should go by some
We
reason.
also say, sorry, dismissed.
But dismissed, but rejected, the word should have been rejected. But why they fail to do so? And my lord, your lordship, my lord, I did not place that judgment where para 44 stated, my lord, that every administrative order or a judicial order should have a reason. If there is no reason, that is absolutely bad, my lord.
But there is another judgment of Supreme Court which says that in transfer matters, one has to join and then.
Yes.
My lord,
make
there,
representation.
my lord, then, my lord, here the case is that the order is, they have not gone for an appeal against that order. Against that order, a judicial coordinate bench has said that you dispose of the representation, then till it's disposed of. You should not give effect to that order. They should have gone for an appeal against that order. There is a judicial order. Against the judicial order, they have passed a speaking order, one line. Regretted. I should know what is the reason.
Let's will turn to page number 36, the order, my lord. Date of the order, my lord. 36. That is 19/9/25. Order is dated 19/9/25, my lord. In the order it says that you pass a speaking order, till then that it means not to give effective. However, my lord, the impugn order, my lord, my friend said that that is not a speaking order. It is passed one day earlier, 18/9. So that this particular order has not been communicated, my lord.
My lord, on
there will be a
19/9, when the counsel for the other side was there, they have said that they have not said anything about that it has been disposed of. I got it.
You will not have it in
Because I got it on 19th. I made a statement. I got it in 19th. After the order was passed.
But these are e-files. They can't be preponed and backdated.
Whatever it is, my lord, I got it on the next day, on 19th, after the order was passed. But my lord, whatever it is it a speaking order? If not, that order also there, my lord. Can that order disposing of my representation without any reason, is it permissible, my lord? That much is my statement, my lord. At page 148, my lord, this judgment at para 44, my lord. May I read it slowly, my lord? Your lordship is well aware of that judgment, but still, then, my lord, my duty is to place it before your lordship.
What is the citation?
My lord, 2012 8 SCC, page 148, para 44. May I read it slowly, my lord? 2012 8 SCC 148, para 44. May I read it, my lord? Para 44.
Yes, please read.
It is a settled proposition that not only administrative order, but also judicial order must be supported by reason recorded in it. Thus, while deciding an issue, the court is bound to give reasons for its conclusion. It is the duty and obligation on the part of the court to record reasons while disposing of the case. The landmark of order and exercise of judicial power by a judicial forum is for the forum to disclose the reason by itself, and giving of reasons has always been insisted upon as one of the fundamentals of sound administration of justice delivery system. To make it known that there had been proper and due application of mind to the issue before the court, and also as an essential requisite of principle of natural justice. The reason is the heartbeat of every conclusion. It introduces clarity in an order, and without the same, the order becomes lifeless. Reason substitutes subjectivity with objectivity. The absence of reasons render an order indispensable, unsustainable, particularly when the order is subject to further challenge before a higher forum. Recording of reasons is the principle of natural justice, and every judicial must be supported by reasons recording in writing. It ensures transparency and fairness in decision making. The person who is adversely affected must know why his application has been rejected. I do not know why my application has been rejected, my lord. Regretted. I should know why it has been rejected.
Yes, Mr. Bora.
Well, that should be reason, but this is fast earlier than the before the order is
We'll still
No,
pass it
this will
to
this will
fresh order.
extend the interim order and then direct the final reason order, my lord.
All right. We're disposing of the writ petition.
Lordship.
But Mr. P.K. Roycholi then answer for the petitioner. Also her is Embedded Raji Leonard, additional senior government advocate, appearing for respondent numbers 1 and 2.
1 and 2 and 4 lordship, 5 lordship, district commissioner
1, 2,
and 5.
5, 1, 2, and 5. And Mr. Esbora and its 10
3 and 4.
BTC representing respondent numbers 2, 4, 2 and
What
4.
what two, my lord? 3 and 4.
3 and 4.
3 and
With 3 and 4. Sorry. Next, in view of the nature of order proposed to be passed from my issuance of notice on the respondent number 6 is dispensed with. Next, please. In brief, the case of the petitioner is that by an order dated 28/10/2024, pairing number, page 22. Pairing numbers also. The petitioner was issued by the secretary, BTC. The petitioner was transferred from the post of CDPO, DOTMA, DOTMA, ICDS project to the post of CDPO, Kokrajhar, ICDS project. As the incumbent at the ICDS project, Kokrajhar was due to retire on 31/10/2024. Thereafter, by a notification under number E-228 651 of the 362 dated 19/8/2025. Various 23 CDPOs were transferred, including the petitioner, whose name appears at serial number 14 of the said notification. So, on the ground that on the ground stated in therefore, the petitioner had submitted a representation dated 29/8/2025 to the Secretary to the Government of Assam, Women and Child Development Department, against the said transfer. How the said representation was rejected by letter number is 39. Letter number so dated 18/9/2025. Stating that the prayer for modification of transfer order dated 19/8/2025 has been regretted. Next part, it is posited that without having notice of the said letter dated 18/9/2025, the petitioner had approached this court by filing WPC 5506 of 2025, and this court by order dated 19/9/2025 had directed the respondent authorities to dispose of the representation dated 29/9/2025 by a speaking order. On by referring to the case of Union of India versus Ibrahimuddin, 2012. 8 SCC 148. It is submitted that he said order dated 18/9/2025, being an administrative order, did not contain any reason. And accordingly, this petition has been filed again by the petitioner. Next, the learned standing counsel for the BTC has supported the order dated 18/9/2025, stating that the said order was passed prior to the order passed by this court on (19/9/2025). The said submission is also endorsed by the learned additional senior government advocate. Next paragraph, be that as it may, having seen that the order dated 18/9/2025, by which the modification of the transfer order was regretted, does not contain any reason. Court is inclined to allow this petition at the motion stage without issuance of notice on the respondents. by providing that on a receipt of a certified copy of the order, or on receipt or from the petitioner, or on receipt of a downloaded copy of this order from the standing counsel for the BTC. But from the standing counsel, from the additional senior government advocate, from the joint secretary of the government of Assam, from Women and Child Development Department. Well, pass a speaking order, disclose the reasons regarding disposal of the representation of the petitioner dated where is your representation?
20 page, my lord, 33.
Representation. Of the petitioner dated 29/8/2025 within bracket annexure 8 to the date petition. Full stop. The taking note of the ensuing Durga Puja festivities, comma, it is, the court is inclined to provide that on the next working day, the petitioner shall submit a certified copy of the order before the in the office of the Secretary of the Government of Assam, Women and Child Development Department. Along with a copy of the petitioner's representation dated where was that?
Page 33.
33. Yeah. 29/8/2025. And on and within how many days is Sarji? 10 days?
Worship, due to ensuing holidays.
No, we have said that this will be given to you in the next working day after the holidays.
Lordship. Oh,
After that, how much time you need?
2 weeks, Lordship.
2 weeks.
Just for, I shall convey this, Lordship, but even though.
Okay. Within 2 weeks thereafter. So the petitioner shall also provide his email address, her email address to the email address. We're submitting the copy of the representation, for which the order passed by the competent authority shall be transmitted and communicated to the petitioner. Next paragraph. Till the disposal of the representation dated 29/8/2025, passing a fresh order from the page 30, impugn order, impugn notification number so and so, dated 19/8/2025. not be given effect to in respect of the petitioner, whose name appears at serial number
14.
14.
1-4.
Next paragraph is made clear that this order shall not affect any other transfer orders. The transfer made by the order dated, notification dated 19/8/2025. Next paragraph, accordingly, the petition stands disposed of at the motion stage without issuance of notice on the respondents. Next paragraph, in the learned additional senior government advocate shall also transmit downloaded copy of this order to the Women and Child Development Department of a government of Assam to bring the order to the notice of the said authorities.
Obviously.
Already we have said two things. Number one, either he will submit a certified copy within the next working day of after the holidays, or the authorities can also dispose of based on the downloaded copy sent by you.
Obligement.
Supplementary item 22.
Maybe. This matter is relating to the recovery from the pension, my lord. My lord, earlier, my lord, we had filed this is connected with item number 15 of the today's wish, my lord. Earlier, we had filed this petition, my lord, for finalization of the pension, my lord, without the proposed recovery, my lord. In the meantime, my lord,
At the time when you were in service, when you were retired,
my lord, I have retired, my lord.
what was your position you were holding?
My lord, I was a junior assistant, my lord, and I had retired from service, my lord, on.
You were junior assistant.
Yes, my lord. Retired on 31/7/2023, my lord.
This is connected with item 15.
Yes, my lord, item 15.
Yes. Yes, you have any instructions?
My lord, here. Actually, what happened, my lord, in item number 15. He has filed this for pensionary pension benefit. Before that, we have issued pension papers. Pension we have issued. Whereas as per government the department's direction, we have made recovery. But he has got this after filing of this case. Yes, that is why now it is burden lies with now. We already issued to Treasury officer. Now, in short, now Treasury officer is to not to recover now. If Rafiq Masik case is taken under consideration, if Miller, there is a lordship. In my humble submission as on date, because question of recovery also is there. If it is not recovered so far, then maybe state till next day. Or that is Treasury will say this point.
In this item number 15, which is the impugn order.
My lord, there is no impugn order, my lord.
20 February 25, where is that?
Prayer was, my lord, to finalize the pension, my lord, without the proposed recovery.
Asking you something, please respond to it. We have limited time today.
My
What's the
lord,
difficulty in answering the court query?
that was, my lord, again the proposal, my lord, at page 19 of the petition, my lord, annexure 5, my lord. Resubmitted the proposal, my lord, with this recovery, my lord.
And it is second petition, which is the
Second
clear number 1, which is the
Yes, my lord.
order.
Order is, my lord, at page, my lord, 25, my lord, annexure 7. my lord. Here, my lord, the pension was finalized, my lord, with recovery of an amount 4,19,725.
Page number?
Page number 25, my lord.
Who the petitioner is, sir? Who the petitioner is? Nothing to.
Nothing.
Nothing to attorney. Petition?
The next page, my lord, 26, my lord, it was finalized by PPO number, my lord.
People have a problem. Ready. Work of liquidation, लिखा था उसको।
I'm just asking you, we are finding some difficulty.
My lord,
Why did not you take leave of the court to withdraw this writ petition and file a new one? Now you see the complication you are making. In the first case, we have issued notice.
yes,
Page 19, that's why we asked you that question. In that case, the letter dated February 25 by the executive engineer to make recovery was challenged.
Hmm.
Correct?
yes,
Now, in that writ petition, you have no interim order.
yes,
And
there,
based on the recommendation of the executive engineer, a pension payment order has been released,
yes, my lord.
ordering a recovery.
Yeah.
And this order is not under challenge in the second writ petition.
My lord, finalized, that is by the second.
Please understand, when we stay the proceedings in the second writ petition, what happens to the payment order? The request for recovery is already there. So you should have withdrawn the first petition and made the challenge, consolidated challenge the second writ petition.
My lord, actually, my lord, first writ petition is infructuous, my lord, as the pension has been finalized, my lord.
You take a call, we don't know. That's why we are saying we are having a problem in understanding. Unless the recommendation to recover is challenged, PPO can't be defective.
My lord, final order was finished, my lord, in the second writ petition, my lord.
Final order, you see the department says that recover that amount. There has to be also set aside. First and second, first you don't have an interim order.
First, my lord, earlier writ petition was only for the proposal of the, my lord, recovery, my lord. That was not finalized, my lord. We came with, for the, against the proposal, my
No,
lord.
it's okay. I can't make you understand. I can just tell you our problem. We did not say that we want you to understand.
My
We
lord,
said that we have a problem and then we are asking you a question. We are never saying that you please understand. Okay, we stop the recovery for the time being. Let him do whatever he does.
That's to be now as matter is before the executives. No, not that's there is also my addition. Financial justice, it can be updated.
Yes, will be a
If provided, it is not recovered by the executive.
not yet recovered.
That may be recorded, if not. Yes. নাই করবা এটা পোটে কব না পোটে কব মই কেনে নাই কোৱা পোটে কব এতিয়া আমি কেনেকে কম
See,
নাই
in item 15, say,
15
what is that?
K Uddin, my lord. K Uddin.
K. Uddin, learned counsel for the petitioner. As well as Mr. C. Barwal, learned standing counsel for the.
For accountant general, my lord, in this case 7, That's one more comment.
Corporate
In both the
General.
cases.
And Mr. Anupadhyay and Standing Counsel for the Irrigation Department.
1 to 4, Lordship.
It's going to be saying that.
We'll get it. No, go on.
The learned counsel for the petitioner has submitted that during the pendency of this writ petition, the petitioner has been served with a copy of the pension payment order. And the said pension payment order issued on 30/6/2025 has been assailed by the petitioner by filing WPC 5701 of 2025. Accordingly, no order is required to be passed in this writ petition. Next, list this matter. List this matter along with WPC 5701 of 2025. So that in item 22. Heard Mr. Kyuddin, learned counsel for the petitioner, also heard Mr. Anupadhyay, learned standing counsel for the Irrigation Department, Mr. C. Barwa, learned standing counsel for the Accountant General, and Mr. H. Alia, learned standing counsel for the Finance Department. Next one, the case of the petitioner is that while working as the junior assistant in the establishment of the executive engineer from Mangalday Dalgaon Sipaja division within bracket irrigation, the petitioner had superannuated from service, and as per the pension payment order bearing dated 30/6/2025, the direction has been issued for recovery of a sum of rupees 4,19,725, purportedly against the statement of excess drawl received from the employer. Next, issue notice. Returnable on 29/10/2025 as the learned standing counsel for the Irrigation Department, Finance Department, and the Accountant General has accepted notice. I requested extra copies of the writ petition. They served on them in course of the day. Next, the prayer for staying of the recovery is opposed by the learned counsel, standing counsel for the respondent departments. Nonetheless, having noted that the recovery of rupees 4,19,725 is required to be made as per pension payment order dated 30/6/2025. Only as an interim measure, the court is inclined to provide that till the next date of listing. The Treasury officer Dharan, Mangalday, within bracket respondent number 6 shall not give effect to the recovery. Of this 4,19,725 as indicated in the pension payment order dated 36/2025 issued by the Office of the Accountant General within bracket PNE, bracket was Assam. Next, the petitioner shall produce a certified copy of the order before the respondent number 6 to bring the order to the notice of the same authority.
Lordship, if not already recovered, Lordship.
If not already recovered, not recovered if under so and so, if not already recovered.
My lord, monthly pension be released, my lord.
That will be later on because
Otherwise, my lord.
because we have to see.
That will come once the payment order is there.
Yes, yes.
It will always come.
Yes, it will come.
Has anybody stayed it? No.
No.
Your friend is also not there.
He was the step with the order.
But we will not release, my lord.
Appearing for the pension department.
From the pension department. Okay, your name?
Sharma.
New Sharma. Okay. So standing counsel for the pension department. Okay. Sir, in this, just a moment, in this item 15, before the, where we have said that
15 to 24, not the poor matter.
this is last to say, it is, the court takes notice, just give me that file. Court takes notice of the order dated 24/9/2025, passed in WPC 5701 of 2025, that it has appeared to the court that this writ petition has become infructuous. After that, you say that list along with Swan's.
23.
This matter relates to compassionate appointment. Petitioner father was working as a constable under the Directorate of Civil Defense and
When did he expire?
He actually missing. He was found missing. He was missing on 24/9/2012. And thereafter, 24/9/2012.
Yes.
And thereafter, one FIR was lodged, as final report was submitted, and Lordship will find that Annexure 3, page 26, this is the police report.
26.
Yes, page 26, my lord. Police report submitted on 18/2/2015. That he could not be traced down.
Yes.
And thereafter, my lord, petitioner filed an application on, my lord, 2/11/2016.
But there is a difficulty.
Well,
108.
yes, my lord. That has been observed, my lord. Because, my lord, in the year 2018 and 19, his case was placed. But his case was, my lord, kept in abeyance, my lord, as because 7 years was not completed. And thereafter, my lord, he approached this honorable court. Lordship will find the order at page 42. The relevant portion starts from page 43, my lord. Second paragraph, my lord, it has been discussed. Page 43, my lord. So this honorable court was pleased to direct the authority to consider.
See, there is one difficulty.
Well,
You have seen 108. What is the name?
Presumption of.
This is 108. You see, we are, please don't take it that we are making any comment on this order at page 43.
Yes, my lord.
But look at 108.
Yes.
See the language, how it starts. Burden of proving.
Relation in the case of partner.
Just read it loudly. I will also refresh my memory.
Burden of proving that person is alive, who has not been heard of for 7 years, provided that when the question is whether a man is alive or dead, and it is proved that he has not been heard for 7 years of those who would naturally have heard of him if he had been alive, the burden of proving that he is alive is shifted to the person who affirming.
So there is no presumption. There is no presumption. And the declaration of death is then normally given under 108 by a civil court.
Yes. Pursuant to that order, DLC has considered his case.
Okay.
So DLC recommended, Lordship will find that page 50,
50.
Yes, DLC meeting was held on, Lordship will find that next paragraph, next page 51. Meeting was held on 23/12/2022. Page 51.
But then the proposal, then the scheme has been discontinued. When was it discontinued?
2017.
This
17.
17.
17 is the distinct lordship. After 17, there is no compensatory this scheme. It is compensatory pension scheme. And death certificate report is of 2019.
19.
So if we consider the death certificate as the date of death, then pension scheme will lie, lordship. Otherwise, and if we consider the date of missing of 2012, then it is. Again, the fact, lordship, that the civil court order presumption, if he affirms it, he has to prove.
Once there is an order of the court, we said that we are not disrespecting the order of the court. But Mr. Barwa,
Lordship.
yesterday the notification was placed before us.
Yes, lordship, it is before me,
So
yes.
can this be disposed of on the direction that it will be considered on the basis of that?
Yes, yes, under point number 4, lordship, yes. Well, listen, it will not come under point number 2 because in the repair there is no such rejection thing, because his case was as per his, this is not a place. But point number 4, lordship, they are discussed about a delay, and Devabate Tetiwari, that thing was being discussed. So under that scheme, it will be considered.
You are aware of it? No.
Well,
So we dispose of the petition saying that it will be considered on the basis of that notification which Mr. Barwa submitted before us yesterday.
August, 3 August, 25.
Does he? Hey, Joakati. Joakati se protest the notification. Adi Joakati protest the You just correct the order when it comes. By the time I'm dictating the order.
But
Heard Mr. N.K. Kalikal and counsel for the petitioner. Also heard. Inspector case brother and government advocate appearing for
all the
respondents. Next paragraph. In brief, the case of the petitioner is that his father, what is the name of your father?
Inamul Haq. Inamul Haq.
no, it's
No, no.
Father, he's Idris Ali, madam.
Oh, Idris Ali. Idris Ali.
His father, Idris Ali, while working as constable in 1st one ST first. A SRF battalion under Assam Police took leave for 5 days on 24/9/2012, and while returning to his residence, went missing from Gwalpara. And accordingly, a missing report was filed on 8/10/2012, and thereafter a formal FIR was lodged on 18/10/2012 before the officer in charge from Gwalpara Sadar Police Station, which was registered as Gwalpara PS case number 507 of 2012. Full stop. The by a police report dated 18/2/2015, comma, it is reported that the father of the petitioner could not be traced out. Which page is the death certificate? You have shown us a death certificate. Where is
Death
that?
certificate, what you will find at page 41.
41. And thereafter, the petitioner had obtained a death certificate in respect of his father, wherein the date of death is provided as 24/9/2012, and the said death certificate has been issued on 27/12/2019. Full stop. Accordingly, the petitioner had applied for appointment on a compassionate ground on
2/11/16. 2/11/2016.
2/11/2015.
16.
16.
Yes.
That it was that prior to the issuance of death certificate. So that they were appointed, applied for compassionate ground. First of the district level committee in its meeting held on 21/3/2018.
Yes.
Had recommended the candidature of the petitioner.
No, my lord, it was rejected. My lord, Lordship will find that page 36.
First, it was rejected.
Matlab kept in
Meeting date is
kept in abeyance, my lord,
rejected. Huh?
not considered.
Where is that?
Page 36, my lord.
Serial number?
11, my lord.
So was not considered as the period of 7 years from the submission of the application for appointment under compassionate ground is yet to be completed. Full stop. Thereafter, the petitioner approached this court by filing WBC 5369 of 2021. And this court by order dated 18/7/2022, disposed of the writ petition with the direction to consider the petitioner's application for compassionate appointment directed that the application of the petitioner be placed before the concerned DLC for consideration in its next meeting, subject to condition that the same has not been considered earlier by the DLC, further providing that if the said application has been considered by the concerned DLC, the decision taken therein shall be communicated to the petitioner. Next paragraph. Thereafter, the application of the petitioner for appointment on compassionate ground was taken up for consideration, and as per the minutes of the meeting of the DLC, Gwalpara, held on 23/12/2022, the name of the petitioner was
Page
page
52, page 52, my lord. Para
was
2.1.
recommended under paragraph 2.1 of the said minutes for appointment on compassionate ground. So, however, as nothing has happened, the SLC is not taken up.
Not taken up.
As nothing has happened, the petitioner has filed the present petition under Article 226 of the Constitution of India for issuance of a direction on the state level committee to consider the case of the petitioner for appointment in the post of constable within the grade 3 as per the government scheme. Next paragraph. The learned government advocate has submitted that prior to the minutes of the meeting of the TLC, Gwalpara, which was held on 23/12/2022, the state government has withdrawn the appointment on compassionate ground scheme, and the scheme for compassionate appointment was superseded by compassionate family pension scheme with effect from 1/4/2017. Accordingly, it is submitted that the petitioner would only be entitled to the benefit under the compassionate family pension scheme next paragraph. The learned government advocate in his usual fairness has submitted that considering the various judicial pronouncements in the issue of compassionate appointment, and in light of the judgment passed by the Supreme Court of India in the case of State of West Bengal versus Debabrata Tiwari and others, yes, Supreme Court in yesterday's order, the Government of Assam, Department of Personnel has issued an executive order bearing number dated 30/8/2025, and on a query of the court, the learned government advocate has submitted that the candidature of the petitioner can only be examined under paragraph
4.
4 of the said executive order dated 30/8/2025.
Immediate. This is the sub financial crisis and civil asylum.
Next, accordingly, in light of the said executive order dated 30/8/2025, referred above, the court is inclined to dispose of this petition at the motion stage by direct, don't say that, dispose of the petition by directing the. Now, who is the authority? to take a decision?
Police authority, Lordship, like home and the DGP. SP. It is SP or SP, no?
It is Director General of Civil Defense and Command.
Response number 3.
No.
Or I think
Director
SP.
is not the appointing.
I think SP, response number 5.
The Commissioner and Secretary responsible to
Who is the appointing authority in the constable?
Director, madam.
Director.
The Director it is.
Okay, then the Director General of Civil Defense and the Commandant General of Home Guards. You say that your father was.
Yes, madam. The department is called, madam, the Director General of Civil Defense and Commandant General Home Guards.
No, you said that he was, while he was serving as.
Police Constable, madam. In ASRF.
ASRF means.
Assam Special Reserve Police, madam.
This is under Director General of Civil Defense.
Yes, madam. I am told, madam.
Director General of Civil Defense and Commandant General of Home Guards. Within bracket response number 3. Who is stated to be the appointing authority for.
Yes, Lordship, because page number 52. Page number 52 of the repetition, Lordship. The Deputy General of Civil Defense, Deputy Commandant General of Home Guards has submitted the following vacancies.
Okay.
Page number
So,
52, Lordship.
Appointing authority under paragraph 2.1 of the minutes of the DLC held on 23/12/2022. To take a decision in respect of the petitioner, considering the DLC recommendation dated 23/12/2022, and in light of the executive order numbers also dated 38/2025, issued by the Government of Assam from a Department of Personnel. Next, according to this petition stands disposed of at the motion stage without difference of notice on the respondents. Next, the petitioner shall produce a certified copy of the order before the respond number 3 within a week.
No, sir.
So to enable the said authority to do the needful.
Obliged.
But look at this one. Yes. Item 24. Item 24. For some time. For some time, nobody is there. 25. You are wanting the
Those are
enumerated in
happy
higher
petition.
higher pay.
Happy, but the case is simple. Case is simple. Petitioners are a retired employee of Guwahati Oil Refinery. They are covered by the Employees Pension Scheme 1995. Under the Employees Pension Scheme, my lord, the employee concerned does not get the pension on the entire salary. They get the salary on the ceiling limit. And this ceiling limit was withdrawn on 22/8/2014. And the employees and employers were given an option to exercise their option to contribute the entire amount starting from the scheme. So accordingly, my lord, large number of persons could not exercise their scheme within the stipulated period of 6 months. And subsequently, they exercised their option, but their option was rejected. And ultimately, the Kerala High Court, Rajasthan High Court, and Delhi High Court passed an order in the favor of the employer. The employees, the Provident Fund Authority went to the Supreme Court. Supreme Court declared, no, the earlier government's order is correct. Now, but Supreme Court granted 4-month window period to exercise their option. And accordingly, these options were exercised by us. After exercising this option, our salary, our pension was enhanced. So, Lord, just have a glance on pension order. Page 176.
Page
176.
186.
176.
186. 186.
No.
Pension on higher pension.
No. Your worship, while you get page 176 first, then I shall come to the other.
Yes.
Now, here your lordship will find the employee concerned was called upon to a pay amount. There is, your lordship will find this amount was above the forward here with the below the mentioned documents submitted and for your provision and equal. So, no, amount na? Okay. The straightway your lordship come to page
86.
186. That will be better. I have given a list, Miller.
List na 86 में मुझे ये था.
186 onwards.
This is Narayan Goswami. Pension amount on higher wages is 3714.
It was one of. Now, Miller, just a minute, Miller. 186 to 194.
No, but what is wrong in this page 210?
Miller?
18/1/25, what is wrong in that 18/1/2025 order? This clarification at page 210.
There is a notification at.
No, yes. That your lordship come to some subparagraph 2. Exempted establishment eligibility for pension on higher wages. Eligibility for pension on higher wages should be determined on the basis of the extent trust rules of the exempted establishment in consonance with the direction of the Honorable Supreme Court in such and such case, amended the post decisions on 14/12/2022.
in Sunil Kumar's case. The application number is such as may not be considered. Now, let's straightway should come to Sunil Kumar's case.
From page number 100.
100.
There's the
Relevant
three-judge bench
page.
order. That is the three-judge bench order.
Yes. And in that 3 judges bench, that extension period was given, page 147.
But we have not been able to,
147 page.
but we have not been able to find out on reading of this order that what is wrong in this 210.
Oh, so 1810 order. 1810 order wants to say,
From a conjoint reading of this judgment and 210, we have
Yeah.
not been able to pinpoint the error in this 18 January 2025.
yes. So let us come to the Supreme Court order, my lord. 170,
147.
146 page.
না বলেন যে রিডিউস করে দিয়েছে এটা তো বুঝতে পারছি না তো।
দাঁড়াও আগে আসুন। পুলিশ করেন।
No, because this says you have to extend your the option to be given within 4 months extended time.
Yes, yes. Only 4-month time was given, and
Yes.
in pursuant to that extension, my lord, we exercised our option. And we were, all of us paid a very, very higher amount. The amount which we paid, we gave an annexer, my lord. Annexer টা কোথায়?
In fact, what I am proposing to do is that we issue a notice, including the notice on your prayer for interim relief, because if it is payment of hire, we can't make that payment without hearing the other side.
No,
why-
payment was made to us.
No, we understand, but still they have stopped it. According to you, they have stopped it.
Yes.
Yes.
So for direction to make payment, we have to hear the other side. So we'll have to issue notice in your prayer for interim relief also. Ex parte order cannot be passed to give you a higher return.
No reason given for stopping.
Actually, no such reason was assigned.
Whatever be, but since it has been stopped to issue a direction to make payment, we have to issue a notice to the other side. Ex parte order cannot be passed. You're issuing a notice. Yes, Mr. Dasgupta?
Your Lordship, just a minute, 174 page. Just a minute, your Lordship, as your Lordship desire, I will not stand in your way. 74 to 75
Today
page.
we also have paucity of time.
Ah.
Since the bench is only for half day today, we are really in paucity of time. I would have heard it, but
All that, then Miller, I will not stand it.
please understand our difficulties today.
No, yes. No, subsequently, Madras High Court has quashed this order.
No, it's okay. We can also do it, but
And we have also annexed that
your
order.
direction to make payment
Yes.
includes payment of the money.
All that, as your Lordship desire, I will not. Now, subsequently, what I want to say, this order has been quashed by the Madras High Court.
18125.
We take
Eight-
note of it.
18, huh?
We'll record in the order.
Hmm.
Let me
Your
say,
Lordship may kindly record that order.
let me say Dasgupta and senior counsel, assisted by Mr. S. Chakravarti and counsel for the petitioners also heard.
And for the respondent number one,
Name.
J. Gayan. J. Gayan.
J.
Gayan.
Counsel
It is 174.
appearing on behalf of
Mr. S.S. Roy. Even
Mr. S. S. Roy and CGC
171, no?
for the
Amount deposited per capita. 3 lakh.
respondent number one, 1, 2, and 3. 1, 2, and 3.
No lordship, only one.
But
yes.
Central Provisional Fund, you don't appear for them.
They have their own
They
set of
have-
lawyers, but they
oh,
don't have any
okay,
standing
okay, I
counsel.
was not aware of. For respondent one. And Indian Oil Corporation is not there.
They don't have any standing.
No
counsel.
standing. Okay.
Notice has to go.
in brief, the case of the petitioners is that they were entitled to the benefit of the Employees Provident Fund, the Employees Provident Fund and Miscellaneous Provisions Act from 1952, and
Employees Pension Scheme 1995.
and Employees Pension Scheme,
1995.
So it is submitted that the benefit which the petitioners were drawing was based on the salary which was worked out in the year 2014.
Salary at the time of retirement. At the time of retirement.
At the time of retirement. At the time of the respective retirement. And thereafter, the petitioners
Higher pension, were paid higher pension from.
Exercise
were
our
permitted-
option
were
for
permitted
higher
to-
pension.
were permitted to exercise their option for a higher pension.
And accordingly, they were called upon to
In-
pay higher
in terms of
money, pay some 174.
In terms of the judgment
Supreme
and
Court
order
judgment.
dated
14/11/2022.
4/11/2022.
Yes, sir.
Passed in-
Reported in.
passed in, passed by the Supreme Court of India in the case of the Employees Provident Fund Organization and another versus Sunil Kumar B and others.
Before 2023.
Full stop. The learned senior counsel for the petitioner submitted that
We have deposited the
pursuant
amount,
to the
page 174.
option exercised, the petitioners had deposited the required contribution,
Yes.
and they had started receiving a higher
Pension.
provident fund pension benefit.
Yes.
Pension
TPO.
Full stop.
up to June 2020.
However,
Up to June 2025.
up to June 2025.
From July, it was.
It is
From July, it was again below.
that pursuant to a clarification issued on 18/1/2025 within bracket annexure N, bracket closed,
We are applying.
the with effect from July 2025, the
Actually, no reason was given to us, though we are apprehending that this might be the reason.
oh, okay. Okay, then don't say that. We'll say that however, with effect from July 2025, the payment of pension amount was reduced. Most of the petitioners apprehend that the same might have happened because of a clarification issued by the Employees Provident Fund Organization on 18/1/2025 within bracket annexure 9/7 annexure N.
2025.
To stop, the learned senior counsel for the petitioners has further submitted that under a similar challenge for the Madras High Court had interfered with the said clarification dated 18/1/2025.
And Calcutta High Court also passed in all that.
Page 237, my High Court's setting aside of.
Okay.
Page 237.
Calcutta High Court.
Paragraph 42.
Perfect.
Calcutta High Court.
Next, accordingly agreed by the reduction of the pension payment amount. The present petition has been filed in the Article 226 of the Constitution of India. Next, issue notice, including notice on the prayer for interim relief, which is made returnable on 31/10/2025. The petitioner shall take steps within a week for service of notice on the respondent numbers 22.
Steps.
5. By registered postal ID as well as to by service of the process to the email by routing the process through the court and to serve the process along with the soft copy of the writ petition with all enclosures to the respondent numbers 2 to 5. Next part of the respondents shall take note that the prayer for interim relief shall be taken up for consideration on the next date of listing. Next list on 31/10/2025. We have given you direction for issuing service through soft copy. Process it through the registry and then send it by. And to her also a copy.
Yeah.
Single copy gives to her. Yes, item 24.
My lord, I'm extremely sorry, my lord. This matter may come up after vacation, my lord, because some instructions are awaited. I could not contact the petitioner, my lord.
Item 24. Puts on the prayer made by Mrs. S.V. Chaudhary, Learned Counsel for the petitioner. List the matter after answering puja vacation. It's MD Bharat and standing counsel for the transfer department is also.
No problem.
Obligement.
Item 12 for admission.
Yeah, please, your lordship, may kindly pass over the matter for the time being. My senior is online for 21.
We
Please,
take up, we'll have to adjourn it after the vacation.
My lord, in this particular case, my lord can dispose of whatever, my lord, that certain direction was issued on the last occasion to provide certain documents, my lord, to release his pension, my lord. Pension payment order we have received, but he was not submitted that Aadhaar card, life certificate, all those to the bank, my lord. In the last occasion, my lord, that
When
was
the council
also.
come, she's let her instructing council come.
Yes, my lord.
Take it after some time then.
My
You
lord.
want to dispose of.
13.
This petition is for pension of the petitioner that he retired about 3 years back. Kindly peruse the last order, my lord. The last order, the submission was made that and the for provisional pension is already processed.
Lordship, as per my last instruction received on 24th September, Lordship, the sanction of provisional pension of rupees 29,760 per month with all other allowances as admissible against Sri Sanjit Kumar Das, the petitioner, Lordship, has been accorded by this office letter dated 9/9/2025. Accordingly, the concerned DDO, that is the election officer Hojai, has prepared the provisional pension bill in respect of Sri Sanjit Kumar Das with effect from February 2023 to August 2025 and submitted to the office of the Treasury Officer Hojai. Details are given here below, Lordship. In the instructions.
My lord, a copy may be.
Whether Lordship
A
they have
copy may be
received it
served,
or
not received, my lord. Till date, not received, my lord.
Give a copy to him.
Lordship,
We'll just record your statement. Give a copy to him.
Lordship, I'll provide him a copy.
Just give it for the purpose of orders. Mr. MG Kadir, Learned Counsel, Vice President. Next, Miss.
U Sharma for respondents 2 to 5.
Government
Government
advocate for respondent numbers 2 to 5
2 to 5.
has produced a copy of instructions dated 24/9/2025 indicating that by way of bill number 25 dated 16/9/2025 TO2 bill number 29 dated 16/9/2025 sanction has been accorded for provisional pension bill of the petitioner with effect from February 2023 to August 2025. Which has been submitted to the Office of the Treasury Officer. So this said, letter contains the bill number and date, comma, particulars of the period of bill, comma, the bill amount, as well as the token number and date. And for the learned counsel for the petitioner submitted that he has no instructions about the same. But as per his instructions, the petitioner has not received the provisional pension. As per the copy of the instructions.
These are okay.
Which was produced by the learned for the respondent is handed over to the learned counsel for the petitioner. And to the counsel the petitioner to have the to enable the petitioner to verify the same.
It is always presented to the Treasury Lordship.
It's okay, we are not disputing it. We are giving copy to Mr. Kadip, let him
Lordship.
verify. Next para accordingly. The matter stands adjourned today. To enable the learned counsel for the petitioner to obtain instructions. List on 24/10/2025.
Date 24/10 oblige.
Item 14.
My lord, I'm sorry, my lord. I think 12, my lord, I was arguing in other court, my lord. Next just opposite, my lord.
Item
I think 12, my lord. I'm very sorry, my lord.
Item.
Item number 12.
12.
My lord, item 12. My lord, in this item 23rd, my lord, April, there is a directions, my lord. This court has quoted that, my lord, he has not submitted certain documents to release his pensionary benefit as well the gratuity, my lord. Still now he is not cooperating with us, my lord. So direction may be issued to the petitioner to submit the document. Thereafter, my lord, we are ready, my lord.
Look, we have filed a reply, my lord,
Reply to the order of the court.
to the affidavit in opposition, my lord.
Please give us a simple answer.
Yes, my lord.
Have you complied with the directions to provide them with particulars?
My lord, several representation, kindly see, my lord. All were represented and we have been persistently pursuing before them. Now,
We have asked you a question.
lordship,
Can you give a pinpointed reply?
my lord,
We have asked you a question. Can you give a pinpointed reply?
yes,
Please give it.
yes.
Please give us a reply.
Yes, my lord.
Give it. Yes, my lord is what?
Yes, we are willing, my lord. We
You are
are willing,
willing.
my lord.
Please tell us in the, look at the calendar, there is a calendar. By which date you will give the documents to the bank? There is a calendar there. Go there and check it and tell us. Give us a date. You have filed a writ petition. They are saying that these give us documents will give you the, what do you call this, payments. And you are saying we are willing.
No, what is the intention, my lord? I have never received such documents, my lord, as projected by them. That is the problem, my lord. 2-3 years,
Okay, we'll take it up after the vacation.
my lord,
don't
you
have
may
time.
kindly dispose with the matter, my lord.
We are not disposing of. We are really fed up. We are asking a question. This is ready. The council is saying that he's ready. Their bank is ready to make the disbursement. We are here to give you an order, and you say that we are contesting this matter. What is the difficulty in telling us that on that day we'll go and give it to the bank?
Definitely will go, my lord. Definitely will go, my lord.
Yes.
Definitely will go, my lord.
Tell us a date.
And my lord,
That date is
on any date, my lord,
You
working days.
tell a date. What is the difficulty? You ask your question, you don't give an answer.
Monday.
Well, some time may be given,
Kiss
well,
calendar
15
देखो
days,
ना।
10 days, well, thereafter we will process. It can be disposed of, but probably, well.
We'll take it up after the end of the matter. Please wait, take your decision. We don't have time to.
On my lord,
Wait.
on 13, my lord.
On 13.
Yes.
Okay.
13, no? As you can. So, I could go office.
Well,
You see, we
give
don't,
him 10 days time to.
you see, we don't mind smart people, but don't be over smart.
My lord.
We want smart people. Young lawyers should be smart, but don't be over smart. It doesn't help you. He's willing to give you, he's making a statement before the court that they are willing to give it, but they need documents like Aadhaar card and all.
Process to, within 10 days you have take from the court and then deposit.
This is 13th, we make it 13th.
The documents.
Date पे ना देखो ना.
In my reply, my lord, that.
Where is that requirements? What
My lord, the annexure A page 19, my lord, in my affidavit filed by the respective 10, my lord. We have personally team or visited to his residence
Okay,
also.
which page? Which page?
Page 90, my lord, running.
90.
90. Annexure A, my lord, in my reply. We can submit the documents and release them. We can dispose of them, sir. Dated 40/10/24, my lord. By letter.
Page 90.
Yes, lordship. Pension payment process, my lord.
Calendar देखो ना.
Annexure A, my lord.
We try to stay the pension in bank.
Sir, they would like to submit the following.
आज कितने? 26 में. 30 के मान देते जाए.
Valid document Aadhaar, PAN card duly verified by authorized official.
Second.
28, 29. अच्छा.
And we told the government, then we will be paid when it's time to submit it before the branch. Thereafter, we will process it. Only process now. Normally. Taking valuable.
But Mr. Your name?
My lord, N. Gamori.
N.K. Morel and counsel for the petitioner. Also, Mr.
K Das, your lord,
K. Das.
10 and 11, my lord, for the
Learned
bank.
Counsel for respondent numbers
10 and 11.
10 and 11. For the State Bank of India, respondent numbers 10 and 11.
Didas on behalf of each firm, pending strictly.
Didas.
Didas on behalf of each firm. Planning council, respondent number 4.
Appearing on, learned counsel appearing on behalf of Mr. B. Das, standing counsel for
P. Sharma on planning council, respondent number 4. Copies of the
4, okay. B. Sharma, standing counsel for respondent number 4. And Mr. C.K.S. Barwa, learned government advocate appearing for respondent number 2. And PhD. Just write it down. Learned counsel appearing on behalf of Mr. You are appearing on behalf of Mr. Sutia. Learned. Let me see, learned standing counsel for the PhD. That's correct. Agreed by the non-payment of pensionary benefits, including gratuity, despite being superannuated on 30/11/2022. On the present date, petition has been filed under Article 226 of the Constitution of India. The learned counsel for the respondent numbers 10 and 11 has submitted that in his affidavit in opposition in paragraph 4, mention has been made about the documents which are required to complete the pension payment process. Full stop. The learned counsel for the petitioner has submitted that the branch, the authorized officials of the State Bank of India had even visited the petitioner's place to enable her to do the needful, but petitioner had not cooperated by producing the valid documents. Full stop. It is stated that the details of the documents are mentioned in the affidavit in opposition filed on 19/6/2025, as well as in Annexure A thereto. Next paragraph. The learned counsel for the petitioner submits that the documents which are mentioned in the affidavit in opposition as well as in Annexure A thereto shall be provided to the branch manager. Which 10 or 11 to whom?
My lord, here is the, my lord, 11.
11.
Branch manager Bokakhat, my lord, 11.
Bokajan, not Bokakhat.
Sorry, my lord, Bokajan.
To the respondent level 11, I, the branch manager, State Bank of India, Bokajan branch, within 13/10/2025. Accordingly, the matters are adjourned today to enable the petitioner to submit the documents as mentioned in the said affidavit in opposition and Annexure A thereto. The respondent 11 within as proposed by the learned counsel for the, within the time as proposed by the learned counsel for the petitioner. List of expert accordingly matters stands adjourned today. List on 24/10/2025 for updated instructions by the authorities of the State Bank of India. You want to know why we became angry? Why I had made an outburst? You want to know that?
No.
You want to know why the court had expressed its outburst against you? You want to know it? You come to this.
My lord.
Come to this. They said affidavit. In the last page, the bank has even given a what you call the Google Map photograph showing that they have visited your house. This is the photograph making a statement that the bank officials have gone to your house for the documents. For pension payment order, if you want the bank managers to be dragged to your home to get a home delivery service, you will.
Actually, I'm sorry, my lord, that address shows Sirajan, my lord. Actually, that is not my
Please
own.
don't tell us. When we can point out a document, you must also understand that we have gone through the brief and then we are here. So don't do it next time.
Anyhow,
We ask you a question, you make a straightforward reply.
we'll comply, my
But
lord.
if you want it otherwise, we'll be happy. Yes, item 14.
Oblige, my lord.
May I please, your lordship?
Yes.
This this petition is related to appointment of the Tribunal, lordship.
What happened?
In this
the
case,
hearing?
what happened, lordship, an appeal was prepared by the respondent number 6.
What has happened?
Then what happened, my lord, already passed and matter, I think lordship may close the matter, my lord.
It is in your favor.
Yes,
It
in
was,
my
order
favor.
was passed out 22/9.
22/9. Okay.
This is the order,
So
lordship.
it's okay. We take your word for it.
22/9, জগালে পাইছে না? উপর আছে। 24/9,
24/9,
24/9.
24/9. Okay.
Yes.
This is SK Nargis, learned counsel for the petitioner, has stated that on 24/9/2025, the appellate authority has concluded the hearing, has already passed an order. A speaking order.
Yes.
In respect of the petitioner. So accordingly, it is submitted that in view of the final order being passed on 24/9/2025, this writ petition will become infructuous. Infructuous. You want to challenge that order?
No, lordship, actually, this respondent number 6 prepared an
This
appeal before the authority.
Okay, that.
I was appointed, lordship, and it is right now in my favor, my
Okay, I
lord.
understand that. I
Lordship.
couldn't follow it. I said that this appeal was dismissed and you said that you are happy.
Appeal is in my favor right
In
now.
your favor, okay.
Lordship.
Okay,
No order was passed in the appeal, that is why we filed this writ
okay,
petition.
okay. Mr. J. Andy, learned standing counsel for the Revenue Department, and Mr. C.K.S. Barrow, learned government advocate, are present. None appears on call for the respondent number 6. Pushpa, next paragraph. In view of the disposal of the appeal on this matter, having been rendered infructuous, stands closed.
16.
Keep level.
All right.
Yes, any instructions?
As per my instruction, lordship, the petitioner's husband, at the time of his retirement, declared that his wife was expired, lordship. This is my instruction, lordship.
Okay, anybody is present for item number 16?
Yes, Kamini Bala.
No. None appears on call for the None appears on call for the petitioner.
The notice has not issued, Lordship.
No, but the petitioner must be here, whether
Yes,
notice is
sir.
issued or not. No, notice was issued 20 August.
Oh, yes, sir. Sorry.
Notice is issued. None appears on the petitioner. Next para, however, Ms. S. Barber and CGC has submitted that as per instructions received by her, comma, the husband of the petitioner at the time of submitting family declaration had declared his wife as inverted commas expired. Next, be that as it may, as the petitioner is absent on call on the matter stands adjourned today. List again on 24/10/2025.
Item 7 with 8, order for.
Give her back this letter.
Make preview, Lordship.
It is fixed for consideration the IA, my lord,
Yes, Lordship.
in pleading.
Implement petition, Lordship.
Contempt number 1 was, we changed Lordship, transferred to another department, and MS Lakshmi Priya had joined in his place, Lordship.
You see, Lakshmi Priya, you've given this notice.
Yes, sir.
7.
Yes, Lordship. Place of him, we have intimated her, Lordship.
No, but this is not how you are required to give a notice.
Order should be coming.
If you come to page 7,
Yes, Lordship.
correct? The notice to the new incumbent must be to comply with the order of the court. You have given the intending respondent a notice that you want to impede her.
Yes, Lordship.
But that doesn't make her a contempt now. You see, when does a willful contempt happen? The incumbent must be aware of the order. It's not comply with the order. Correct?
Yes, Lordship, but we have communicated the order to the earlier commissioner, Lordship, we have taken.
Contempt is always personal.
Yes, Lordship, that is.
Contempt is always personal. And you know, something which I don't know whether nowadays it is happening or not. But let us say for example, my earliest secretary was there taking dictation just before he has come.
Yes.
Correct. Now, the present secretary may know or may not know what has happened some time back. So if the order is not complied with, he is not in default. It is personal to the incumbent. You must tell the incumbent that he is required to comply with the
File
order.
press petition along with the order, Lordship, then.
We'll
that
keep it
case.
pending.
Yes, Lordship,
We'll keep it pending.
Yes,
You give her a notice and then
along with the order.
along with the order, and then you file an affidavit and take it off the court.
Oh, yes,
Correct.
Lordship.
Because the incumbent must know and she must be in willful default or non-compliance of the order.
Yes,
Correct. You're just keeping it pending.
yes, Lordship.
You're Mrs. K. Pujari.
K. Pujari, yes, Lordship.
Mrs. K. Pujari, and counsel for the petitioner on a query of the court has submitted that he may be, that the petitioner may be given liberty to put the opposite party sought to be impleaded.
Lordship,
Uh,
page number 3.
It's okay. Notice to comply with the Directions contained in the order dated 2/6/2022 passed in WPC 936 of 2022. And to bring the same on record by filing an affidavit. So the prayer is allowed. We just, Mr. S. Bharat will answer for the respondent.
So, one,
Respondent,
there is sole respondent, but it is there.
no. The respondent one is present.
There is actually two contemner, Lordship.
No, one and two, two.
Two contemners. We have file IF in respect of one implement of one contemner number one, Lordship.
No, again, you are wrong.
Two, not two
Again,
contemners.
you are wrong.
Two contemners here, sorry.
No, you are wrong. I'll tell you why. From the, had I not read the cost title, I would have made a mistake. You see in the cost title of the writ petition, you have a copy of the writ petition. Oh, sorry, the contempt petition. You have a copy of that.
Yes.
There is only one respondent, Nidhi Dahal.
Yes, Lordship.
Correct.
Yes, Lordship.
Now you want to implead. You are saying that Megha Nidhi Dahal is not in office.
Yes, he's transferred.
And MS Lakshmi Priya, she's the new incumbent in the office.
Yes, Lordship. Right.
Your prayer is to implead. Your
Yes.
prayer is to implead. But actually what you're doing is substitution.
Yes, substitution.
But substitution would be wrong. To take a what you call take a considered decision. What happens to the earlier contempt? If that Megha Nidhi Dahal is not obeyed the order of the court, and you substitute her, she gets exonerated. Do you want that?
Usually we do like this, Lordship.
So don't do it. You may not get many judges who will explain it to you. You will not get. You may not get. I not say you will not get. You may not get. So I think you better. Better option to you would be to withdraw this and to make a prayer for impleading, not substitution. That means the one serial number 1 will remain, and the others will be joined as 2 and 3. Correct.
One is already transferred. He's the commissioner, Lordship. So now he's
You see, we can tell you, we can't explain it to you.
okay.
Correct.
Yes.
Sit down for 10 minutes, think over, and then tell us.
We have included their file impeachment petition.
But you see, the cost title, you have changed it. Number 1 remains, one is now substituted by MS Lakshmi.
MS Lakshmi. Yeah.
So that number 1 is, your prayer is for impleading, but what you're doing is,
Paragraph 2 that Lordship, his name may be deleted, Lordship.
yes, that's why.
That's why,
It is
Lordship.
substitution.
It is substitution.
Deleting means substitution. Mr. Bora, please explain it to her.
Oh, I got that, 3. Okay.
Yeah,
Yes, I got it.
Withdraw this, give a notice and file another one. Implead them as 2 and 3.
2 and 3.
Correct?
2 and 3.
Correct.
We have to file.
Yes.
To file a fresh.
These things we have a very bad background. I come from the civil court. Therefore, we have lot of difficulty in in throwing off the CPC out of our head. What is substitution? What is impleading? These are few things we have learned at very hard way.
Lordship,
Just a moment. There's some administrative work. Correct. For you, we are keeping it pending. You file an application and withdraw this. Just change that over. For the applicant, 6 leave of the court to put the new incumbents to notice what compliance of the order dated so and so passed in WBC so and so, and thereafter to file a fresh application for implementing them as the respondent numbers 2 and 3. On the said period, the matter stands adjourned today, granting leave to the petitioner in the connected contempt petition to put the new incumbents to notice and to file an appropriate application. Till then, the matter stands adjourned today. List again on 27/10/2025. In the meantime, do it.
Item 9.
May it please your lordships. The instant IA has been filed for improvement of the.
Just a moment, Mr. Bora is left. Just see if the Bora is there. Yes, this IA is for. Yes, finance. So, Mr. Just wait. So, Bora, you where is Mr. Saria? Mr. Bora, both of you don't go out. Now we also required in the next case, Mr. Salia, who has gone out. He informed me that all. No, that's okay. But you have come, but he has left. In the next case, his requirement is there. Mr. Salia, in this matter, Mr. Bora will be required. In this matter, we allow the implement? Yes. Okay. Your name?
A. Hussain, my lord.
Mr. A. Hussain, London Counsel for the applicant. As well as Irrigation, who is there? You are there. I forgot your name.
DS New York.
Ms. DS New York, standing person for the Irrigation Department, representing respondent numbers 1, 2, and 3, as well as Mr. A. Shalia, standing person for the Finance Department, appearing for the respondent 4. Next para, by filing this interlocutory application, the applicant, who is the petitioner in the connected WPC 7494 of 2023, seeks to impede the Commissioner Secretary to the Government of Assam from a Finance Department as respondent number 4. On hearing the learned standing counsel for the Irrigation Department and the learned counsel for the Finance Department, the parliamentary interlocutory application stands above, permitting the implement of respondent number 4 in the connected writ petition. This application stands disposed of, and the writ petition will say, in view of the order passed in the connected IA Civil 3055 or 2025, allowing implement of respondent number 4, the petitioner shall Submit amended cost title to the AOJ civil pending section for being incorporated in the debt petition and for correction of the CIS system. Full stop. List the matter. What is this? Regularization. Okay. List on 28, 10, 29, 10, 2025. After that, we'll pass orders in on this. Yes, item 9, item
10.
8. Mr. Bora, in item 7, item 8 was also connected.
Item,
What is to be done in item 8?
item 8, Lordship will have to quit like that, my lord, because of the item 7, my lord. That similar, same order have been, one time is line, so they have.
So they are tagged.
So that
Okay. In item number 8, you pass a separate order. As this matter is tagged with contempt case 160 or 2023, list this matter as and when the said contempt case 160/2023 is listed. Okay. Item 10.
For implement of the mallet as respondent number 4 and 5. During pendency of the contempt petition, mallet, the incumbent of respondent number 1 and 50 transferred. And in their place, mallet, new incumbent has come, mallet.
You put them to notice.
Notice, mallet, kindly please see, mallet, page 11, mallet.
Page 11. Okay, heard Mr. K.R. Fatgiri and transfer for the petition for the applicant. Also heard.
Mr. K.
Your name?
AK Ghosh on
A.K. Ghosh and counsel appearing on behalf of Mr. K. Kumar and additional advocate general for the state. Sorry, K. Kumar and advocate appearing for respondent number 1. Next para. Filing this interlocutory application, the applicant who is the petitioner in the connected contempt is 534 of 2023, is seeking implement of respondent number 4 and 5. Respondent number 4 and 5 as the respondent number 4 and 5 in the connected contempt petition. Next, the counsel for the petitioner, applicant has submitted that both the new incumbents have been put to notice of compliance of the order of the court by letter dated 3/10/2024. Within bracket annexure B, bracket closed. Accordingly, this pair made in this interlocutory application stands allowed. This application stands disposed of. In the connected contempt petition, you write, heard so and so. In view of order passed today in IS Civil 3095 or 2025, allowing implement of opposite parties number 3 and 4 as respondent numbers 3 and 4 in this contempt petition, the petitioner shall submit a amended cost title to the AOJ contempt section.
Before the
Mr. Levin, to the contempt section. AOJ contempt section for being incorporated in the contempt petition and for amendment of the correction of the central CIS system. The same shall be done within a week. Next para. List this matter on 27/10/2024.
Thereafter issue notice, my lord.
After that, we'll do it because because without the CS system, we are finding it difficult.
Oblige.
Item 17.
Yes, if that's 79. And they will look at it.
Okay, this is a contempt lordship. I represent respondent number 2 and 3.
Yes.
So we are doing the needful, but it is taking some time because all documents are coming from different offices. Lordship.
We take up the matter.
And Lordship, respondent number 1 also, Lordship, he has been replaced. I am not representing him. In any case, Lordship, the principal secretary is no longer there. I think they need to implement him. Well, implement. Lordship, and Lordship, for 2 and 3, I am representing. We need some time, Lordship. We are doing the needful.
Okay. Mr.
A Borwa.
A Borwa and counsel for the petitioner is present. Sam Bhagwati and counsel for the respondent numbers
2 and 3.
2 and 3 has submitted that as per instructions received by him, the authorities need some more time to do the needful, and accordingly he pays for an adjournment to bring updated instructions.
Lots of instructions I have, but I require time. Updated instruction for today also I got some instruction, but
for the
we
next
need time.
also, for next also you'll have to have updated instructions.
Lots.
It is submitted that although he is not very sure, but the respondent number 1, the respondent 1 is no longer holding the post of principal secretary to the government of Assam, Department of Animal Husbandry and Veterinary Department, Government of Assam, Department of Animal Husbandry and Veterinary. The Learned Counsel for the petitioner shall take note of the statement. Next list on 27/10/2025.
Much of it.
Just make a mention for this. Okay. The pendency of the contempt petition will not be a bar for the respondent authorities or compliance of the. Suspense.
18.
Yes.
May I please the lord.
Yes, Mr. Ali.
But here, my lord, the petitioner, my lord, he was selected, my lord, for the post of Gav Pradhan on 3/1/2023. Selection was silenced, my lord, by an unsuccessful.
Where is that order you want?
Page 33, my lord. Page 32, my lord. Relevant option is first order, my lord, 8/2/2023.
What is the correction you are wanting?
My lord, here, my lord, the last portion on page 33, my lord. There is an observation, my lord. It is, however, provided that lordship got it.
36.
33, my lord.
33.
Lordship. The departmental council sought time for instruction that was allowed, and this order was passed. My lord.
No complaint shall be issued to the private respondent without proper verification by the competent authority as regard his eligibility to participate in the selection process.
And thereafter, my lord, page, my lord,
Will not be
34.
issued to the private respondent. Who is the private respondent?
He is the, my lord, unselected selected candidate. He silenced my selection, my lord.
So you are the respondent.
I was the respondent in the writ petition.
You are
Dilbar Ali, my lord.
respondent number 3.
Lord.
Okay.
Then, my lord, on 11/4/2023, my lord, writ petition was closed, granting liberty to the petitioner, my lord, to file appeal, statutory appeal, my lord. But in the last portion, my lord, page 36.
Yes. What has happened to the appeal?
Nothing, my lord. No hearing was conducted. And because of this observation, my lord, no verification of document, nothing has been done, my lord, for appointment. Page 36, last sentence, my lord. Until such time the appeal is disposed of, the interim order so and so shall continue.
What is the, what you call, this writ petition has been disposed of?
Lordship. Page 35. So appeal is, my lord, under the stated provision, my lord.
Mr. Andy. Last, I think we issued orders about a year back.
Lordship.
That all this year back or more than that. That all these appeals under the executive instructions should be taken up by an authority and done. After that, the government appointed someone.
Yes,
Lord,
Lordship, the
that
appeal-
Director of Land Records, my lord, now he is the appellate authority.
But can you find out why this appeal has not been disposed of?
No, whether the, if my lawyer friend provide me the appellate number, Lordship, then I can take the inspection.
No, you see, he is agreed by the interim order.
Lordship,
But
on
the
Lordship, my
appeal-
lord, kindly see the last order.
No, please try to understand.
Lordship,
The writ petition was filed by one Kismat Ali.
Lordship,
Now, whether this appeal is there or not,
Lordship. But the appeal has been filed by the, my lord,
yes,
that.
file or not, what is the position? He will not know. Have you appeared before the authorities? No. In the appeal?
No, my lord. He filed, my lord, because he filed an IO, my lord, for transferring the appeal. At that time, my lord, appellate authority was not there. So in page 39, my lord, he filed an IA that he has filed appeal. Appeal was not placed before the appellate authority. And subsequently it was placed, my lord, and number has been given, my lord. Number is 41 of 2024.
Where is it?
I have mentioned, my lord. In paragraph 9, my lord, last paragraph, paragraph 9, page 9, my lord, last sentence, my lord.
41, no?
After the order of the small court, my lord, it was transferred. My lord. Case to Borbeta.
Appeal number
41 of 2024.
24, no? Lordship, let me take instructions on the appeal, the status of the said appeal.
Okay. Who was the advocate for the petitioner in that writ petition?
Mr. Sharma, M. Sharma.
Have you served copy to him?
Okay. Dispose of case, my lord.
Oh, you have not read the
Even then, Lordship, my lord, kindly
under
see
the
the
Advocates
last.
Act, what you call the brief held by the lawyer will continue for the purpose of interrogatory applications and order. Similarly, is there is an order 3 rule. Order 3 rule 2, order 3 rule 3 CPC. Advocate once engaged continues to be engaged even in review application. But then you are delaying your matter. If I issue notice.
We'll try to solve, my lord.
Heard
Again.
Mr. Harari and asked for the petitioner. Also heard Mr. CK's government as well as the other Mr. J. Henrik Lander. Standing counsel for the Revenue Department. In the meantime, this review petition has been filed for modification of the order dated 8/2/2023 and order dated 11/4/2023 passed in WBC 6/5 of 2023. Actually, it is projected that initially an intra-court appeal was filed against the said order. However, the interrogatory application as well as the unnumbered appeal was withdrawn with liberty to approach the single judge for clarification of the order. What is this 11/10/23?
11/4/23.
11/10/23, page 44.
11.
What is this?
Similar order, my lord. There was similar observation was there, my lord. It was, my lord, last accordingly, it is clear vision was made that there is no embargo, my lord.
According to this review petition has been filed. If you notice returnable on 31/10/2025. Petitioner shall take steps within 3 working days for service of notice on respondent number 3 by registered post with AD. Requisite extra copies of the petition be served on the learned government advocate and the learned standing for the Revenue and Disaster Management Department in report for the day. Next one. In the meanwhile, the learned standing for the Revenue and Disaster Management Department shall make an attempt to obtain instructions regarding the appeal. Yeah.
Appeal 41.
Which page was that?
Paragraph number 9.
Paragraph 9.
Totally page. Whether
Page 9.
the page number
9.
Page 9, my lord. The appeal number is
41 of 2024.
41 of 2024.
In connection with Rule 162 within bracket small c of the executive instructions has been taken up for hearing or not. And the authority before which the said appeal is pending. Next. Learned standing for the Financial Disaster Management Department is permitted to send a downloaded copy of the order to the competent authority to enable him to obtain instruction. List on 31/10/2025.
I have to pay the name. On the calculation.
Okay, the before that, after that you say
21, no?
This one's done. The registry shall reflect the name of G. Assam in the course of this by listing the matter next.
Lordship, your fix is on 21st.
31st.
There shall not be any bar for on the.
No, because it amounts to modification of the order. We can't do it without notice on the other side.
Lordship,
That's why we are asking you, if you could have served the notice on the council who was appearing for the petitioner, we could have done something. Yes, item number
20.
20.
Publish.
In this case, my lord, the petitioner already died, my lord. So, I file IA, my lord, for substitution.
Okay.
The next case 12, my lord.
For
He
the
died
moment you are
on
there. We allow this prayer. We allow this application.
I have to.
But Mr. P.R. Patgiri, then the counsel for the applicant, also heard.
Of time, my lord.
Mr. N.N. Upadhyay and its standing counsel for the Irrigation Department, representing respondent number 1, 4,
my lord. 4 maybe, my lord, represented by the BTC, my lord, council.
Huh?
BTC council, the respondent number 4, my lord.
4 is chief engineer. Chief engineer, he can't appear.
Sorry, my lord.
And it's a C. Barber and it's standing counsel for the respondent number 5.
My lord.
The pension, she was there, the girl, the lady.
Sharma.
Pension department.
You, sir, my opinion.
No, pension and public defense, I am pay first.
You'll appear for them. Then Mr. C.S. Barber, will be for 1 and 2.
Not for one, lord. I cannot, irrigation has their own method.
Acha, he'll be for 2.
Only for,
Irrigation is N.N. Upadhyay. 1 and
the irrigation is for 1 and 4.
One
Mr.
and four.
No,
One
By day.
Fight it, and fight it.
And a by day.
finance.
चलिए
It's a Chalia.
ये चलिए
A Chalia and standing counsel for the finance department. And this BTC,
Rita Das Boro, my lord.
Our Boro.
Har Boro, my lord.
RD Boru Rita Das Boru Rita Das Boru
RD Boro.
MS
because he's also there, Mr. Bora was there.
Boru ने
He's
की
out.
he Boru
Just find Mr. Bora.
My lord.
Rita Das Boru
He'll appear.
No, I'm here for. Yes, Boro.
My lord.
अच्छा
Just find Mr. Bora if he can appear.
Yes,
Number 1.
Just leave a gap for BTC, standing counsel for BTC.
allow her to like allow her कोई कोई तो लगा मैंने कोई नहीं बोला
It is projected in this application that the petitioner in WPC 3439 of 2024 is the mother of the applicant who has expired on 9/4/2025,
and मैंने तो आवाज दिवी को गया
leaving behind the applicant who is the younger son and 2 others as her legal representatives. Full stop. The applicant supports his contention by producing next of kin certificate issued on 19/6/2025 within bracket annexure B. And it is further projected that the other 2 legal representatives have no objection. For the petitioner to claim the benefit left behind by his deceased mother. And accordingly, prayer for substitution is made. Next paragraph. Having heard the learned counsel for the respondents, the prayer is allowed. The applicant namely
तो नाम तो लिखा है
what is your name?
Budhiram Soran, my lord. His son, my lord. Budhiram Soran.
Where have you given this name in the hospital?
On the date of realization, his son, my lord. Budhiram Soran. Applicant. Next of kin certificate, my lord.
Soren, Budhiram Soren. Accordingly, this application stand is allowed and disposed of. In the writ petition, you say, Hertz Pencil, in view of order passed today in the connected I civil 3186 or 2025, or the substitution of the petition has been allowed. So accordingly, the learn so allowed by impeding Budhiram Soren as a person to represent the deceased petitioner. Accordingly, the substituted petitioner shall file amended cost title and hand it over to the AOJ civil pending section for being incorporated in the writ petition and for making necessary corrections in the CR system. Next one, list on 3/11/2025.
But Rita Das Boromada already left the court, my lord.
Mr.
Rita Boro, my lord.
R. Boropura. And he goes in BTC. Shall we allow it impeding? Yes, item 21.
As per the last order, my lord, we were required to file an affidavit.
It's already
Which
become
takes-
too, it's already become too bulky.
My lord. The pleadings have gone up to, my lord, 1,000 pages. My lord.
Yes, not only that, 1837 pages, to be exact.
My affidavit, my lord, my contribution is around 100 pages, not more than.
No, not that. But what we want would now be concise gist because it will be very difficult to follow.
Exactly. In fact,
If I am to take up hearing, please assist me with giving me a synopsis of our short list of dates.
that we have already prepared.
Prepared, yeah. For you also.
I have submitted a 20 pages document, but I did not receive the information. That is why, otherwise, if I receive the information, that 20 pages document, then 1800 document may not be required to be required. Today I received
No, that's not what he's saying. He's saying that his notice of 20 pages. It doesn't say that the requirement is 20 pages.
Because Lordship, I did not receive information. That is why.
It's okay, but
If I get the information,
when we take up the hearing on the exit, you be prepared with, give us a short synopsis because it will be very difficult to read this bulk of
Actually, today the matter was listed with respect to some pending use lordship. With respect to some pending use lordship. They are repeatedly given inconsistent statement. They are repeatedly given different statement from last 2 years lordship. Now their statement are totally random lordship.
We can
Kindly
consider that only when we
give some
hear the
opportunity.
matter. You can only consider that when we hear the matter.
Lordship, today only I received it. Kindly allow me some time as well
We'll
as some
give you time, but
opportunity
we are,
so that I can defend my claim. Lord.
We are giving you time, but we are saying that please be prepared with a short notes for hearing.
Lordship, if I get the information, then I can prepare a short note. Lordship,
What
because I
information?
was not receiving the information. Lordship.
No, the issue is very simple, my lord.
No.
There was a
don't
departmental
depend on
proceeding.
them. Whatever you have to say, please make it a concise statement. Of
They,
not more than
they are not responding, Lordship. This is why. They are not responding my
No,
submission.
there was a departmental proceeding.
let them not make any submissions. If you want to make yourself heard, please give us a small gist.
Lordship, I can only submit that these are the points that I'm not receiving. That only because those points
You
after
see,
getting.
these matters we are telling you, these 1837 pages. We are not going to hear it without a list of dates and the synopsis of your notes.
But regarding list of days, I already prepared. Already actually submitted in my repetition. If required, then I can submit another list of days.
I don't say it is required. But if you don't give it to me, if I am the bench hearing the matter, if you don't give it to me, I'll not hear it. I'm not saying that is a requirement. You have made it clear, this is 1837 pages if I have to read. And if you're dependent on that, then please be sure that we are not going to read it. We are asking you that whatever is there, make a brief of not more than 15-20 pages. Make it a concise statement which you want to argue. You give it and we'll take up the hearing. If you're expecting me to hear the matter of 1837 pages without any notes, that is, I don't expect the hearing to take place in near future. You are the petition in person, therefore we are telling you.
Lordship, I can submit a 20 pages document, but in 20 pages document, Lordship, I can only submit that these are the points which are the
Whatever way
points
you want to do,
against which
please
I am
make it
not
a-
receiving response, Lordship.
Whatever you want to do it.
Okay, Lord.
But the return of notes should not exceed 15 to 20 pages. Yes, what is your prayer?
My lord, we were required to file an affidavit. He has raised the dispute that certain medical benefits were not paid to him.
Whatever
It is
we-
our consistent stand that it has been paid.
That's all. Yes.
As per the last order, we were required to file an affidavit, my lord, that we have filed it today. If
You
he
filed
wants
it
to,
today?
we have filed it today. It is on record, my lord. Isn't it? It is on record.
You want to respond to it?
Lordship, kindly give me some time, Lordship, immediately after purification.
It's okay. You want to respond to it?
I have to go through this actually, but I find it very much random, Lordship, because there is nothing. They mentioned that there are some deductions, but they don't mention how they made that deduction with reference to what. They just randomly every pages, every paragraph is random, Lordship. For that, I need some time, Lordship.
That's what we are asking you.
Yes, Lord.
You want to take time and then
Yes,
respond to it?
yes.
Okay.
May not be required to respond, but I will submit my defense then.
The petitioner in person has submitted that he has issued a copy of the additional affidavit filed by the respondent numbers 2 and 3, and he needs some time to go through it and to address the court. Next para. Mr. Endegar and counsel for respondent numbers
2 and 3.
2 and 3. You are for 1. 4, 5, and 6. Who is for 1 then?
One is the Union of India, my lord.
Union of India.
It's a formal party because it's a departmental proceeding of the NRL.
He was here as Barwa.
This Roy's name appears. Huh?
Yes, also.
I don't think he is here.
As Barwa, counsel for CGC for respondent number 1, and the counsel for respondent numbers 2 and 3, and Miss D. Mohanta, counsel for respondent numbers 4 and 5 are present.
4, 5, and 6.
4, 5, and 6 are present. Next para. Yes. The volume of the readings have exceeded.
We are at page 1881, my lord.
1800 pages. All sides who want to address the court shall prepare a brief note of submissions not exceeding 15 to 20 pages to be submitted before the commencement of hearing. Next para, matter stands adjourned today. List on
Immediately after purification, Lordship.
on 29th and 2025.
21, 10.